writ petition, my lord, in the name of the tenants, my lord. So no relief can be granted in this petition as of now, my lord, because relief has already been granted to the tenants, my lord, through the petition. So this matter may kindly be withdrawn, my lord. Disposed of, my lord, as withdrawn.
Okay, on the prayer of Mr. M. Sharma, the learned counsel appearing for the petitioner for withdrawal of the matter. Stop. No, withdrawal of the matter, comma. The matter is disposed of. Disposed of as withdrawn with a liberty.
I'm grateful, my lord.
With a liberty to file again if so advised.
Item 2.
Formality implement of 5, 6, and 7 respondents. My lord, due to my lord, after bifurcation of my lord Barpeta district, Bajali district has been placed my lord formed. So my lord, the 5 is DC, 6 ADC.
So you want to include whom?
5, 6, and 7. Prospective my lord, the opposite parties.
We heard Mr. R.S. Chauhan. R.S. Chauhan, the learned counsel appearing for the applicant, also heard.
I'm appearing on behalf of K. Gopal.
And so, that is one. The instant IA has been filed for implement of respondent number 5, implement of Sri Arthapati Majumdar, in bracket IAS, District Commissioner Bojali, Sharma, Sri Nirmal Jyoti Sharma, ACS, Additional District Commissioner Bojali, and Srimati Paurinita Chakraborty, ACS, District Bojali,
Circle officer.
ACS. See, circle officer.
Yes.
You have no written circle officer.
Yes, my lord.
The circle officer, Orupeta Revenue Circle, as respondent numbers 5, 6, and 7, due to the fact that the district of Bajali has been newly created from the erstwhile district of Barpeta. Full stop. The prayer is allowed. The instant IA is disposed of with a direction to file the amended cause title within a period of 3 days. Full stop.
3 days, 1 week, my lord. Already.
Within a period of a week. Let the matter be listed after 2 weeks. This is disposed of. IA disposed of.
Otherwise.
Petition.
Please, your lordship. Lordship, this matter may be taken up after some time, lordship. Sir, DP Borough conducting counsel of health department is on legs, lordship.
Okay, nothing is there. We'll just close it today.
I have prepared my written submission.
You-
The convenience volume.
Ah.
I'll give it to, then I'll refer to the 3-4 judgment, Your Honor.
Okay, let him come, then we'll just close it.
Madam, in this matter, I am appearing for response number 2. I have already received.
Madam, can you peruse the last order dated 6/4/26?
If lordship comes to the prayer portion, the prayer is basically for directing to the respondent to construct the upgraded school building. And the report I have received, lordship, as per the report from the circular, construction has already started. The construction is going and donated by the local people. And the progress is.
642026.
Level, lordship. I don't know what is.
My lord, pursuant to the last order, my lord, I filed the affidavit on behalf of respondent number 3. I pray, my lord, let it be on Wednesday or my lord, Thursday in the my lord live court, my lord. I am on VC today
Yes.
for the final disposal, my lord. Otherwise, affidavit has been
They
filed.
have filed an affidavit. Okay,
Yes.
okay, your affidavit is on record.
my lord, we have filed it on 34. Probably it will be on record.
Yes, it is there, it is there.
To page 281, my lord, running page.
Yes, yes. It is there on record. Okay.
Yes, my lord.
Okay, then we'll put it when? Thursday?
Thursday, I think yes.
Wednesday or
Thursday is
Thursday?
a holiday. Thursday is a
Wednesday,
holiday.
my lord. Wednesday or next Tuesday, my lord.
Let it be on Wednesday, Your Lordship.
Let it be on
Wednesday.
next Tuesday. Next Tuesday, no. Next Tuesday will be, maybe next Tuesday.
Your Lordship, the issue was with regard to the maintainability of the repetition. I have addressed only on one point, only on one issue. There are other issues also.
No,
of
you
maintainability.
can raise it, you can raise it.
Yes, Your Lordship will permit me to do that because I have already raised.
No, you can raise it. I mean, his affidavits come. Let's see what is there. What is there?
On the last occasion, Lordship has already, my lord,
Yeah.
considered it on merit also, my lord. So we have filed an additional affidavit during the hearing.
Okay, heard. So we'll put it on next Tuesday. Heard,
My lord, my lord.
heard Mr. M. Nath. Next Tuesday means after this, not immediate next.
Yes, my lord.
Yes.
Yes, sir.
Next Tuesday will be
Second, my lord.
Coming week.
2nd of June.
Yes,
2nd of
2nd
June.
of June.
2nd of June.
Okay,
Heard Mr. M. Nath, the senior counsel, assisted by Mr. A. Bhattacharya, the
Your
learned
Lordship, on 2nd of June, I have.
counsel
Not
appearing.
convenient. Can it be on 4th of June, Your Lordship?
4th of June, Mr. Gogoi.
My lord, my lord.
Mr.
Let
Nath.
it be on 4th.
I have a counsel appearing for the petitions. Also heard Mr. B. Gogoi, the learned additional advocate general, appearing for the respondent in Health and Family Welfare
Health
Department,
department, my lord.
and Mr. R. Singha, the learned counsel, appearing for the private respondents. Full stop. Mr. B. Gogoi, so the learned advocate general submits that he has already filed the affidavit in opposition in terms of the order dated 6/4/2026, which is on record. Full stop. The parties have, but a joint prayer has been made by the parties, the matter to be listed on
4th of June.
on 4th of June.
For further hearing, Your Lordship.
On 4th of June. Let the matter be listed on 4th of June.
For further hearing, Your Lordship.
No, it is already there.
It's part hard, it's written there.
Yes, sir.
Published.
Deeply obliged.
Item 5.
Mr. Lordship. My lord, kindly let this matter be taken after some time. My senior is next important problem. And coming on.
Pass over for time.
Okay. Each notice I have received Mr. No, we are going to file an affidavit.
Okay, Mr. J, your name?
Please, okay.
This T. Sirka is present for the petitioner. Mr. J. Henry, the learned standing counsel revenue department, submits that he has received the instructions and requires 2 weeks time to file the affidavit. 2 weeks time is allowed. Let the matter be listed after 2 weeks. What about Mr. S.S. Roy is appearing for whom?
No, my lord, I appear on behalf of respondent number 3, 4, and 5, state respondent.
Respond out 3, 4, and 5. And who else is there? So you are appearing for all the parties,
I am for 3, 4, and 5.
3, 4, and 5. Mr. Henry is for 3, 4, and 5. And who is for revenue department?
No, my lord,
Revenue and disaster
they
department.
have, my lord, they're on online.
They are also required to file affidavit.
I will inform them.
Okay, let it be listed.
Lordship, after 2 weeks.
2 weeks.
I'm appearing for Revenue Department, Lordship.
You have not filed any affidavit? You have
I will
not filed
file,
any
Lordship.
affidavit?
Lordship.
Okay, G. Hazarika appears for respondent number 1 and 2.
Lordship.
1 and 2. Mr. G. Hazarika also prays for 2 weeks time to file the affidavit in opposition in the instant case. Let the matter be listed after 2 weeks.
12 and 13.
My lord, may I kindly pass over the matter for the time being? My senior, he's on his way, my
Hmm?
lord, may kindly pass over the matter for the time being.
You are appearing for whom?
My lord, respondent number 4, 5, and 6.
Who are they?
My lord, DCT, Director Employment and Classroom Training.
Who is your senior counsel?
My lord, SP Das.
Where is he?
My lord, he's on his way. He's on his way.
Yes.
On his way, my lord.
Pass over for time being.
14.
May I please, Your Lordship? Matter is regarding non-payment of the bill to the petitioner.
Well, we are awaiting instruction in this matter, my lord. Let's send our letter to the concerned authority. my lord.
May I submit one thing, Your Lordship? The petitioner went to the district commissioner's office, and he has been informed that on 26/2025 instruction has been sent.
No. No, my lord.
That is the specific
The
instruction.
23, but you have filed a case when? 2025 only.
25.
Hmm.
26/2025 instruction has been sent.
So we have sent letter on 17/6/2025, but we have not received yet, my lord. Anyway, we will verify whether any other council has
He
received.
has given me the specific date. He went to the office and they have said that we already sent our reply to the High Court on
They are admitting this liability.
as per his instruction. He has said that
Okay, we'll give him some time. Mr.
after with a fixed date, Lordship.
Mr. D. Chaudhary, the learned Mr. D. Chaudhary, learned counsel, appears for the petitioner. Also, Mr. G. Bokolial, the learned government advocate, junior government advocate.
Yes,
Junior government advocate is present for the respondents.
respond number 2 and 3.
Respond number 2 and 3. Mr. Bokolial submits that he has not received the instruction as yet in the instant case to file the affidavit in the matter first. He prays for 2 weeks time. Let the matter be listed on 11th of June. Let the matter be listed on 11th of June. By that date, the affidavit in opposition shall be filed by the government.
15.
Maybe, Your Lordship. Lordship, for the widening of the
Hmm?
for the widening of the national highway, my lord, some land required by the authority, my lord, and his residents are demolished, my lord. Now only Lordship, kindly page 28, my lord. Only Jirakpulu was fixed, my lord. 8,30,001.
They haven't filed an affidavit. Why?
Instruction, Lordship. We have communicate to the respondent.
Hmm?
Respondent number 2 and 3, we have already communicated.
Hmm.
But we have not received the instruction.
Well, it may be disposed of with the direction, my lord, if he is entitled, my lord.
Hmm?
Already fixed, Lordship, kindly see page 28, my lord. Already, a joint committee was already assessed, my lord, and it was passed. Order, my lord, page 28, my lord. Last line, my lord. Present Jirakpulu.
One second. You are Mokibul Hussain Laskar.
My lord.
The specification of the building and present Girard value after verification is so much.
8,30,147.
Huh.
So, Lordship, it may dispose, Lordship, with just direction, my lord, particular date, my lord.
You verify this already it has been verified. Huh?
My lord.
After verification.
After verification, if it is found correct, then you should release it, release the money. Heard Mr. J.U.N.M. Laskar, the learned counsel for the petitioner. Also heard Mr. S.K. Hazarika, H.K. Hazarika for respondent numbers
2 and 3.
2 and 3.
I am appearing for 1, Lordship.
MS so G. Hazarika for respondent number 1. And you are Mr. R.K. Talukdar, the learned MS so. What is your name? On behalf of Mr. R.K. Talukdar, as the learned standing counsel for NHIDC. Full stop. The petitioner's case is that petitioner has a plot of land covered by DAG number 394 of RS Patta number 1 situated at Rangpur, part 2. Mauja Rangpur, Pargana Barakpur, Pargana, that's Barakpur, under Sub-Registry Office, Silchar Sadar, District Kachar. Full stop. District Kachar, full stop. He had constructed a commercial RCC building on the aforesaid plot of land and carried business having 3 numbers of shops. Also, for widening stroke construction of four lane national highway of Jiribam Road in bracket package number 1 are under Bharat Mala project, the aforesaid plot of land had been acquired by the respondent authorities in the year 2023. For which a compensation of rupees 19 lakh
19 lakhs.
19 lakh 08 189.49 had been assessed and the same had been deposited in his bank account, full stop. Bank account, full stop. It is the case of the petitioner that the aforesaid Jirat compensation had been assessed in his absence as he was not present at that point of time due to his illness. Full stop. His contention is that, the petitioner's contention is that since the Jirat compensation is on the lower side, he had submitted a representation dated 19/7/2024 before the respondent number 3 for physical re-verification of his acquired property and accordingly to fix the compensation, full stop. In response to his representation for re-verification stroke reassessment of compensation, the same was done by the PWD on 24/10/2024, whereby it had been intimated to him that earlier Jirat assessment of the acquired property of the petitioner, his RCC building was not considered, and the same would be considered. Same would be considered as the whole building falls under ROW in bracket right of way of the proposed national highway, and submitted a re-verification report on 22/10/2024, whereby the Jirat compensation of the petitioner had been re-verified and reassessed for an amount of rupees 8,30,146.30. Full stop. Therefore, the petitioner contended that he is entitled to the reassessment compensation of rupees 8,30,146.30. Full stop. In the instant case, no affidavit has been filed by the respondent authorities till date. However, while the matter was taken up, the counsel appearing for the parties are in agreement that the matter can be disposed of for a direction to verify the claim of the petitioner in terms of the assessment of Jirat value made by the respondent authorities by its report dated 22/10/2024. Next, taking into account the aforesaid submission and having perused the assessment of Jirat value, which is annexed as annexure number 9 in the instant petition, it is found that the assessment has been made for a value of rupees 8,30,146.30 by the respondent authorities. Accordingly, it is directed that the respondent authorities, after verification of the verification of the aforesaid GRAT value, and if there is no other legal impediment in payment or release of the aforesaid amount, the same may be released. The same shall be released by the respondent authorities after receipt of a certified copy of the instant order within a period of 3 months, within a period of 3 months, full stop. The petitioner is directed to submit the certified copy of the instant order at the earliest, so that the needful can be carried out by the respondent authorities. In terms of the aforesaid direction, the instant petition is disposed of. There is no other issues.
No, no,
Hmm?
only the phone number, deputy commissioner and district commissioner, my lord.
It's number 31 of the.
2 and 3, my lord. Phone number 2 and 3.
You write respondent authorities, you write respondent number 2 and 3. In bracket, you write respondent 2 and 3. No other issues,
No,
no?
no, 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 nothing.
Because I am disposing it of
My lord, my lord.
with the assumption then because already this value has been made,
Admitted amount, my lord.
admitted amount, because they have assessed only.
My lord.
Only thing is that you need to release the amount.
My lord.
So if there is no other legal issues, then
My-
you can pay him back.
My lord. Obliged.
Get it like
16 and 17.
Make Mr. Lordship. Lordship, here I am playing further.
No further time. Why further time?
My lord, because it is ready, my lord. Just his petitioner is not coming. I mean,
No, there is, I mean, this work doesn't fall under the scheme.
no, it is full. I have document.
Hmm?
I have some.
They have stated there is not fall under it. Why didn't you file the reply?
My lord, within 1 week.
You file reply immediately.
Within 1 week. my lord. I have some document. It is permission.
Hmm?
It is work under the.
This is not under the scheme, they are saying.
But they are saying, but I have something, my lord.
They file it, I mean,
Within
why?
1 week, I will tell,
Last time also 1 week you have taken.
my lord.
Okay, on the prayer of Mr. M.R. Khandakar, the learned counsel for the petitioner, let this matter be listed after 2 weeks. Full stop. By that time, the learned counsel for the petitioner shall file its affidavit in reply to the affidavit in opposition filed by the respondent authorities without fee. Full stop. Let the matter be listed after 2 weeks.
I am did,
Both the matters, huh?
my lord, both. I am did.
18.
Just for time being, Lordship.
Hmm?
Just for time being, Lordship.
For what?
My senior counsel is another court.
Who is your senior counsel?
Jiuddin.
Hmm? Pass about for time being.
Nineteen.
You have instructions?
Lordship, no, I need some more time. Those resolution process, the last date which was placed, it will take some more time. I need updated instruction, Lordship. I don't have.
So why didn't you take the instructions? It was passed, the order was passed when?
The last order was to that some resolution, some steps are being taken. The last order was that some steps are being taken, some time will be needed. So 2 months. was
Last
granted.
order was on 19/12/2025. Then there was an order of 9/3/2026.
Yes.
So what is happening? You will have to tell us, no?
Chief, there no the updated instructions, sometime may be granted.
Okay, Mr. So the learned counsel appearing you are appearing for whom?
Chief, on behalf of Mr. Datta for the PNRE department.
As Datta, the learned standing counsel of PNRA department. Submits that some more time is required to complete the process. Process regarding framing of guidelines, etc. for maintaining transparency in allotment of bits. BHITS bits. Let the matter be listed
After 2-3 weeks.
after 4 weeks.
Alright.
May I please, your lordship?
May I please your lordship? My senior is on another court. Kindly pass over the matter for the time being.
Who is your senior?
PK Roy Chaudhary.
My lord, I have a prayer, my lord.
Who
My
is
lord,
appearing for? Mr. Bhuya. Bhuya is appearing for a petitioner.
my lord, they have filed an IA for, my lord, modification of the interim order, my lord. I have prepared, my lord, an affidavit in opposition to the same. So, my lord, may I pray for another 10 days time to file it on record, my lord.
What is the matter?
My lord, the matter we have challenged an speaking order regarding, my lord, Jirat compensation as well as the land compensation, my lord. I being the attorney holder and the, my lord, along with the executors, my lord, was heard by the additional deputy by the office of the district commissioner and by of an order dated, my lord, 7/1/2025. My lord, our prayer had been rejected and a shared amount had already been paid. So, my lord, some hearing is required.
So they have, I mean, you got an interim order in your favor.
Interim order, my
And
lord, my
they
lord.
file.
File an IA
vacation.
for vacation of the same, my lord. So my humble prayer, my lord, just 10 days time may kindly be given, my lord. I will have prepared the affidavit but could not be filed. So I'll file it within 10 days, my lord.
No problem. They're seeking for some time. Heard Mr. A.R. Bhuya, the learned counsel, appearing for the petitioner in the instant
My lord.
petition. Full stop. Also heard Mr. MS. You are MS
R. Roy.
R. Dhor on behalf of Mr.
R. Roy.
R. Roy for whom? PK Roy
On
Chaudhary.
behalf of PK Roy Chaudhary.
Mr. PK Roy Chaudhary, the learned counsel, appearing for respondents. All the respondents for which respondents?
Respondent number 7.
Respondent number 7. Respondent
Private
number.
respondent.
Okay, Mr. PK Roy Chaudhary, the learned senior counsel, assisted by so and so for respondent number 7. Mr. Bhuya submits that
My lord, I have
an
for
application
6 and 7.
for 6 and 7. Mr. PK Roy
Right.
Chaudhary submits that an IA has been filed in the instant writ petition for vacation stroke modification of the interim order so passed in the writ petition by the respondents, by the respondent number 6 and 7. Also, he submits that he has already prepared an objection to the aforesaid. However, the same could not be filed today. He prays for 10 days time to file the same. The prayer is not objected by the council for the
Only a date may be fixed.
council for the respondent number 6 and 7. Let the matter be fixed on 18th of June.
My lord. Obliged, my lord. Deeply obliged.
MS R. Bora, the learned counsel, appears for respondent number 2 and 3. And Mr. HK Hazarika for
4 and 5.
4 and 5. Respondent number 4 and 5.
May,
Yes, my lord.
may,
Creator, my lord, here is the order passed, my lord, and till
20
today, no affidavit from either side, my lord, neither by the government nor by the private respondent. And my lord,
Yes, 20 should be.
but One thing I have pointed out. One thing I
My
have.
lord, item number 21, my lord. Item number 21 is Abdul Ghani Barbhuya, my lord.
No.
The 21 is not Abdul Ghani Barbhuya. 21 is something else, Mr. Bhuya.
My lord. I'll check it up. I'm sorry, my lord.
My lord, I'm pointing out here in this case, my lord, the private respondent by appearing on behalf of by filing caveat, my lord, and while passing the interim order, their name and the service is waived, my lord. So now, my lord, probably their name was not shown in the cause list. That's why they miss it. Probably.
Whose name is not some private party?
Private party.
You are appearing for whom?
Robin, 2, 3, and 4. Lord.
Have you filed an affidavit?
No, they send on letter. It needs some time. Lord. It takes some more time. Lord.
You want some more time? You got the instructions.
They send on letter taking some time. Lord.
And who is, you are appearing for whom, which department? PNRD?
I'm from Deputy Commissioner.
You are for Deputy Commissioner. PNRD is also involved?
Yes.
You are appearing. Have you filed? No.
The main primary role will be
So you don't have any role. You are not filing an affidavit. Okay. Then private respondent, who is private respondent?
6789.
6789.
Mr. A.M. Ahmed appeared in the para 6 of the my lord earlier order. Your lordship will find my lord page order the 28/1/2026. Para 6, my lord.
So it's regarding the interpretation of the Quran and all.
My lord.
Para 6.
Para 6, my lord. Mr. A. Shamal and Shaman as your lordship.
But Mr. H.R. Chaudhary also appeared in the matter.
Yes, Chaudhary is a senior, but he was assisted by A.M. Ahmed.
A.M. Ahmed.
Yeah. The name not full, I've seen the cause.
Yes, sir.
Okay. Okay, Mr. T.J. Mahanta, the learned senior counsel, assisted by so-and-so, is present for the petitioner. Mr. N. Goswami, the learned junior government advocate, is present for respondent number
2, 3, and 4.
2, 3, and 4. And Mr. A goes for A goes on behalf of Mr. S. Datta, the learned standing counsel, PNRD department for 1 and 5. Anybody else is there? No. None appeared for respondent numbers
6, 7, and 9.
6, 7, and
8, 9.
6, 7, 8, and 9. 6, 7, 8, and 9. 8 and 9. It has been pointed out before this court that the name of the learned counsel appearing on behalf of the private respondent number 6 to 9 is not shown in the cause list. Cause list, full stop. Let the registry reflect the name of Mr. A.M. Ahmed, the learned counsel, appearing for the private respondents in the cause list, full stop. Next, you write on the Mr. N. Goswami, the learned junior government advocate, prays for 2 weeks' time to complete his instructions and file affidavit in the instant case. Let the matter be listed after 2 weeks.
Interim order passed earlier.
Interim order so passed earlier shall continue till the next day.
Deeply.
Lordship, in this case, I have to obtain some instructions, Lordship. According to last order, Lordship, the department is taking some time, Lordship. Can they accommodate, Lordship? 2 weeks time only.
Respondent number 10
Matter
has filed.
release of security deposit money.
We have deducted some money from him after the expiry of the defect liability period.
Yes.
Yes.
But affidavit of opposition by respondent number 10, who is respondent number 10?
And is there
Director of Medical.
Education, Lordship? Director of Medical Education.
He is the concerned person.
He sent the
But he has filed an affidavit.
He has already sent to the government, Lordship.
No, he has filed already an affidavit.
Yes.
Yes.
But
So-
respondent number 2.
So respondent number 10 is director of medical education. You worked where? Your work was issued by
My
whom?
lord, in the GMC.
Huh?
GMC.
By whom?
By the principal, chief superintendent of Gauhati Medical College Hospital.
Principal comes Chief Superintendent, Gauhati
Yes.
Medical College.
Yes, my lord. And later, annexure 9 also issued, my lord. Page 48, my lord.
Okay, let them also come. But this is basically a work under DME. So, your role, I don't know how much role.
Authority is the Medical Education and Research Department. They will have to,
So DME has already filed an affidavit.
yes, Lordship. Proposal he has already.
Okay, let them file an affidavit. Heard Mrs. G. Uddin,
Yes.
the learned counsel for the petitioner. Also heard MSD Bora, the learned standing counsel for Health and Family Welfare Department. For the respondent numbers 1, 2, 3, 10, and 11. Full stop. MSD Bora submits that she is yet to receive the instructions to file an affidavit in the extent case and therefore prays for 2 weeks' time. Full stop. Prayer is allowed. Let the matter be listed after 2 weeks. You file a small
Yes,
matter,
yes.
file an affidavit and.
Yes.
Obliged.
Some clarification was sought for.
Lordship, we already been written to the DME,
Hmm.
Director of Medical Education. Lordship. From them, we have not received that report, Lordship. Because of they are the person who can issue the Lordship, this is the one letter I have received from the Deputy Commissioner. We already been written to the Director of Medical Education on 18/5/2026. And in this matter, Lordship, the DME is not a major party, Lordship. If they made a party, it will be easy to the process. But
You complete your instructions. You complete the instructions,
only because
but
of that report.
only because the state death or audit report name was not.
Lordship, that certificate, that report, they have to be issued by the health department. Otherwise, other process we have already been completed. Only because of that, we could not send them that proposal to them. That
Very small issue, Mr. Hendik. I mean, only thing is that
we
his chairman
already
is.
been we already been communicated with them, joint director and as well as Director of Medical Education. They are sitting on there. We have stated in our affidavit, paragraph number paragraph 5, Lordship. Only because of that, Lordship, it was there.
Okay, heard MS
Dear Bongshari.
here.
Bongshari.
Mongshari, the learned counsel for the petitioner. Also heard Mr. J. Hendik, the learned government advocate, appearing for. Respondent number 5. He submits that in terms of the order dated 29/4/2026, they have written to the concerned authorities for the clarification how the same is yet to be received. He prays for 2 weeks time. 2 weeks time is allowed to complete his instruction. So let the matter be listed after 2 weeks.
Much obliged.
23.
Lordship, I have received instruction. I will go to file an affidavit.
Okay. Or Mr. A.C. Sharma, the learned senior counsel, assisted by Mr. B. Deuri, the learned counsel for the petitioners. Also heard Mrs. J. Hendik, the learned government advocate, for respondent numbers 3, 4, and 5.
3, 4, and 5.
Mr. Hendik submits that he has already received the instructions and requires 2 weeks time to file the affidavit in opposition. Full stop. Let the matter be listed after 2 weeks.
May it please your lordship. Lordship, the IA is filed in order to make some correction in paragraph 4 of the writ petition, Lordship.
What is it?
Lordship, inadvertently, in the paragraph 4, another separate para should have been made, which this separate para, it got included within the paragraph 4, your lordship.
Paragraph 4 or 5?
Lordship, paragraph 4, last part of the paragraph 4 needs to be made into a separate paragraph, your lordship, pertaining to the fact that it is not, it is only a matter of knowledge and not of a record, your lordship, which was verified wrongly in the affidavit, your lordship, due to this mistake, your lordship.
So you'll have to do you'll have to file an amended petition then. You have to file an amended petition. There is no issue. I mean, that can be done. Small mistake they have committed. Heard Mr. Your name?
I.S. Mazarbhai, your lordship.
Heard Mr. I.S. Mazarbhai, the learned counsel appearing for the applicant. The instant also heard Mr. N. Goswami, the learned, as you know, government advocate for
2 and 3.
2 and 3. The instant IA has been filed for correction of the statement made in paragraph 4 of the connected writ petition. Full stop. It is the contention of the petitioner that while drafting paragraph 4 of the writ petition, in the last part of the aforesaid paragraph, it was mentioned as follows. In quotation me, right? It is apprehended that at any moment, the government may initiate action evicting the petitioners from the land as is being done in other surrounding areas of the petitioners. And in that case, the petitioners shall suffer irreparable loss. Full stop. Quotation complete. It is contended that the entire paragraph has been verified as true to record. However, the same has been done inadvertently, as the aforesaid paragraph should have been shown not as per record, but as per knowledge of the petitioner. In view of the aforesaid, in view of the aforesaid, the petitioner contends that petitioner has contended that a separate paragraph separate paragraph may be allowed to cut out from paragraph 4 by taking out the aforesaid lines and thereafter making one new paragraph as paragraph 5A with the following lines. Then you can write 5A quotation, 5A, that it is apprehended that at any moment, the government may initiate action evicting the petitioners from the land as is being done in other surrounding areas of the petitioners. And in that case, the petitioners shall suffer irreparable loss. Full stop. It is also contended that the same some should be allowed to be shown in as matters of knowledge to the petitioner. After hearing the parties, after hearing this, after hearing the respective counsel for the parties, with this, in the instant, IE is allowed for incorporation of the changes also in the connected read petition. Incorporation of the changes in the connected read petition. Accordingly, it is directed to the petitioner to file the amended read petition within a period of 10 days from today also. In terms of the aforesaid, the instant IE is disposed of. Let the matter be listed after 2 weeks.
Much obliged, your lordship.
25.
The state was making instruction. Yes, Lordship. I have received the instruction, Lordship. I have received the instruction.
When?
Instruction I have received on 20th/4.
Then you always say they receive the instruction, but you don't say when. You received the instruction last year also, then you'll say receive the instructions.
Last month. Last month.
Okay, heard Mr. Mr. Ganguly, right?
Lordship.
Mr. A.K. Ganguly? A. Ganguly. So A.K. Ganguly is a different Ganguly from Supreme Court.
Oh, that, yes. Now I
Mr.
can.
A. Ganguly, Mr. A. Ganguly, the learned counsel for the petitioner. Also heard Mr. N. Goswami,
For 2, 3
the
and
learned government advocate for S1, number 2, 3, and 4. Mr. Goswami submits that he has already received the instruction in the instant case and requires 2 weeks time to file an affidavit in opposition in the instant case. He prays for 2 weeks. Let the matter be listed after 2 weeks.
There's an interim order that is.
Interim order so passed earlier shall continue till the next date of listing.
23.
Your Lordship, the conducting counsel is on his legs, praying for time being. Praying for time being. The conducting counsel is engaged on another court.
He was there about some time back in the court. What happened, Mr. Hendrik?
we have not really.
Mr. Bhuya, Mr. Bhuya, he said that he hasn't got the instructions and he wants to, he prays for some time to complete his instructions.
My lord, actually, my lord, that is required, but my lord, notice was issued for the consideration of the interim prayer also, my lord.
We'll receive it on, I mean, we will consider that
In my lord.
on receipt of the instructions.
My lord, then my lord may kindly record that, otherwise on the next date, my lord.
No, it was already recorded in the earlier order. Why it needs
My
to
lord,
be repeated all the time?
read, my
It has
lord.
already been recorded.
Oblige, my lord,
Okay,
oblige, my lord.
heard Mr. A.R. Bhuya, the learned senior counsel, assisted by so and so.
S. Laskar, my lord.
S.
Laskar, Shehnaz Laskar.
S. Laskar, for the petitioner. Petitioner also heard Mr. J. Hendrik, the learned state counsel, appearing for respondent numbers 1, 6, 8, 10, 12, and 13. Anybody else is appearing? Mr. Bhattakur is appearing. 9
I am for respondent number. I am for
Mr.
respondent number 2, my lord.
I. Bhattakur, the learned standing counsel, Forest Department, for respondent number 3, 4, 9, and 11. MSPM Mohanto for
2, my lord.
respondent number 2.
Respondent number 2, my lord.
Respondent number 2, full stop. Mr. Hendrik, Mr. Bhattakur, what about your affidavit? Is it required or not?
From my instruction, eviction is done. Now, whether they're eligible under the policy plan, that needs.
Eviction is already done. So you don't have anything to say now. It's a forest land, right?
They were evicted for forest land.
Okay, so you're not going to file any affidavit.
If requirement.
No, that's up to you. That's up to you. I mean, okay, Mr. Hendrik, the learned counsel, learned state counsel, prays for some time to complete, prays for 2 weeks time to complete his instructions and file an affidavit in the instant case. Prayer is allowed. Let the matter be listed after 2 weeks. Forest Department, it may also. Okay, Forest Department can also file their affidavit if so advised. Let the matter be listed after 2 weeks.
29.
You're appearing for whom, Mr. Musahari?
For all. BTC, for all.
Oh, you are in BTC?
I
Okay.
agree with some third point.
Hmm?
Time taken for.
How much time will require?
2 weeks.
Hmm?
Fix it at after 2 weeks.
After 2 weeks? Okay, heard MS
P. Bora.
P. Bora, the learned counsel appearing for the petitioner. Also heard Mr. B.C. Musahari, the learned standing counsel, BTC. Full stop. Mr. Musahari submits that he is yet to receive the instructions in the matter and prays for 2 weeks time. Prayer is allowed. Let the matter be listed after 2 weeks.
It date may be fixed, my lord.
After 2 weeks.
Of late.
30.
It's a very serious matter.
Why are you not filing a FIR?
Registering
FIR.
It is already registered.
One registered, other one.
That is
The two, right?
This is one aspect of the matter, my lord. My lord, a serious matter, my lord. I was sought to be distrobed. I am an advocate, my lord. In broad daylight, I filed the FIR in March, my lord. They have registered it after filing the repetition. What action they have taken? I am with my daughter only, my lord, in my house.
No, what is that? What is that?
Little has been little lordship.
Hmm?
Second paragraph.
After my husband expired, my lord, he started doing all these things with me, my lord. And me and my daughter in the house. Everything was recorded in the video, my lord. Namesake, the case has been registered. My statement has not been recorded till date, madam. Only namesake they have registered late after I filed the petition, madam.
No, as per their instruction, they have done certain things.
They have registered the case. Earlier occasion also I said, my lord, they have registered the case after I filed the petition, my lord. 4th of May, I filed the petition. 5th, they have registered, my lord. Until that, my lord, my statement, he is roaming about, my lord. Nothing is being done. And Lord, you kindly see the allegation in the FIR, my lord. Both the affairs, my lord.
You file an affidavit immediately.
My lord.
And file an affidavit immediately, and otherwise we'll call the inspector. What is to be done? You keep this with you. Bring all these things on record. And what have you done till date? So first FIR was not raised.
Not registered.
GD entry was there.
GD entry was there.
GD entry was there. And second FIR is registered after the case was filed.
After the case was filed, madam.
And
After 2 months, madam.
complainant was also examined. Complainant was also examined.
Complainant not examined.
Yes, it is written also.
Complainant medically examined.
No, complainant as well as the other witness are examined.
Examined.
Yes.
When, my lord? After 2 months, where is the question of medical examination, my lord? Just protecting him, my lord. Just
Okay, heard
protecting him.
Mr. B. Chakraborty, the learned counsel.
Let them file a reply, my lord.
Appearing for the petitioner. Also heard Mr. N. Goswami, the learned government advocate for the state respondents. Mr. B. Chakraborty, appearing for the petitioner. submits that this is a serious matter involving assault of an advocate in the daylight.
Lady
by-
advocate, my lord.
Assault of a lady advocate in the daylight by the accused persons, full stop. He submits that two FIRs had been filed against the two FIRs have been filed before the jurisdictional OC. However, those FIRs were not registered in time. However, one of the FIRs, that is the second FIR, was only registered after the registration of the instant writ petition. Full stop. He submits that no progress has been done in the instant case. Instant case and investigation is not being conducted by the officer concerned. As expected in a case of such nature. Full stop. The learned government counsel appearing for the respondents submits that investigation is going on and the complainant has going on and the victim has been examined.
Yes, complainant as well as other witnesses are examined.
Other witnesses, victim,
Complainant.
complainant is the victim, right? Complainant and other witnesses have already been examined. Mr. Goswami, however, prays for some time to bring on record by filing an affidavit about the investigation so conducted by the officer, by the concerned officer. Full stop. 10 days time is granted to Mr. Goswami to file the affidavit in opposition, to file the affidavit by bringing on record the aforesaid in the instant case. Let the matter be listed after 2 weeks. After 2 weeks.
Date may be given, madam.
After 2 weeks, let them, after 2 weeks. On 16th of June. Let the matter be fixed on 16th of June.
Timing and disbursement shortly.
Next, the lawsuit. In these cases, my lord, this honorable court has directed to cause an inquiry, my lord. Or will file, is almost public, my lord, will file it, my lord. But will file it shortly. Like issue in this case is this, my lord. The government of India, my lord, they proposed a scheme implemented by the government of Assam. And as per their direction, my lord, we proceeded with the scheme. But all of a sudden, my lord, they stopped paying. So all the petitioners.
But there was some inquiry you were supposed to.
Yes, but we'll cause the inquiry. But we'll file it.
You have caused the inquiry. Inquiry completed.
Yes, madam. We'll file it, madam.
So why haven't filed it?
We'll file it, madam.
When was it completed?
Madam.
Check.
On 13th of May, madam.
13th of May.
I'll file it.
We heard MSO in the council. For the petitioner, also heard Mr. SP Das, the learned standing counsel, skill, employment and entrepreneurship for respondent numbers 2, 3, 4, 5 and 6. Mr. SP Das submits that the inquiry report in the instant case is already submitted, and he requires 2 weeks time to file an affidavit to bring the same on record. Also, 2 weeks time is allowed. Let the matter be listed after 2 weeks.
Right. In my I think number 13, but I'm appealing for response number 2. Same issue, madam.
Okay, appealing in at 13 for response number 2. So same inquiry. Same order.
RTI addition.
Okay.
This matter may be tagged with 2525 of 2024, where affidavit has been filed. The last occasion court has asked to obtain the written instruction. Your Lordship, I have told WPC 2525 and 24, where affidavit has been filed, the issue has been taken up there. It may be tagged with that matter.
Issue is same.
Same.
Okay.
WPC 2.
None appears for the petitioner when the matter was called for. However, Mr. S.S. Roy, the learned CGC, appearing for the respondents, submits that a similar matter with the same issue as is pending before this court, which is registered and numbered as
WPC 2525
525 so and so.
of 2024.
And therefore he prays that the instant repetition should be also tagged with should be tagged with the aforesaid WPC and listed together. He further submits that an affidavit in opposition has already been filed in WPC number, the other case,
Gotcha.
the WPC number so and so, full stop. Let the in view of the aforesaid submissions, let the instant
Series of
repetition.
cases. There are a series of cases. This is the leading case. Okay.
So there are other matters also. Then you'll have to give all the case like a case.
This is the leading case 2525-24.
Then you'll have to write. Along with WPC number and other cases and other repetition. Okay, you just change it that repetition with other cases. Then you write that instant case. The last you write the instant repetition be tagged with the aforesaid other repetitions and listed together after 2 weeks.
Today I have filed the affidavit reply, madam. Yes, for the affidavit filed by the respondent, madam. This is my license is being terminated by the railway, madam.
So you don't do why both of you don't go for out of settlement? Eh?
No, I filed affidavit Lordship because he given warning he has not.
Okay, you have filed affidavit reply.
Yes, madam.
It's not on record. Today file.
Yes, madam.
Okay. Heard Mr. S. Botagoda, learned counsel appearing for the petitioner. Also heard Mr. S.S. Roy, the learned CGC, the learned CGC for the respondents. Mr. Botakur submits that he has already filed. He has filed an affidavit in reply in the instant case today itself. However, the same is not on record. Full stop. Let the matter be listed after 2 weeks.
But there is an interim order.
Interim order so passed earlier shall continue till the next date of listing.
As per order dated 4/11/2025, as per order dated 4/11/2025, both the parties has made their submissions before lordship.
Good the parties
Has made their submissions.
made their submission.
Yes. There's an order.
Then what remains now? Mr. Goswami has come. Yes, Mr. Goswami, what is there?
In this particular case, Lordship, some accused has already expired. Some accused has already expired. And the case is, in this particular case is totally covered by the Supreme Court judgment. In this particular case, FIR has been, incident occurred on 21 and FIR has been filed on 25.
21 and FIR file 25.
Admittedly, IO has been cross-examined and IO has also admitted. Lordship will kindly see the evidence file. Only thing in this particular case, Lordship, I want to say very important.
The accused people, all accused died.
No.
One type.
Not one. I will say, Lordship will kindly see accused Lordship number. Pagunidias died. Gojen died. Prodhan also died.
So how many remained?
There are 6 accused person. There are 6.
This matter was heard before any bench, other bench.
It was hard.
Oh, before whom?
Justice Nayar, not to partner, not a partner matter.
But there's a order from this government.
It is an order here. I don't know why it has been listed here.
It's 4/11/2025.
I mean, Mr. Goswami, this was heard on 4/11/2025, and parties have made their respective submissions in the matter. However, hearing remains inconclusive.
Then okay, Lord.
Let it be there, but he has already heard it.
I have no objection to that.
Otherwise, like if it, I mean, we could have heard it. We could have heard it. But the only thing is that
As per notification issued by Supreme Court, one matter is heard by another court, it will become automatically goes for part of matter within 1 month.
yes, part of matter after one month, after 1 month or 3 months.
1 month.
Part of matter. There is a notification. Supreme Court. Notification
After 1 month it ends. If again it was not part, if it is again not partnered within 1 month, still less.
But it was supposed to be there. That's why it was supposed to be
I have no objection.
listed on 13/11/2025.
I have no objection.
But I don't know why yeah, 13/11/2025 it was listed.
That is why registry has listed this before this court also, because it was not remain as a partner.
No. Mr. R. Sharma, the learned counsel, but the last occasion, this thing was placed by you only. Adjournment was taken by you only.
Only because to take the information regarding death of the person.
Correct, that's what, but this matter was otherwise listed. But I don't know why it was not listed before him. Okay, we'll place it before the registry. Let's see. I mean, if it is, if as per the notification, if time has elapsed, then they'll place it before this income. Because there is an order here.
Conviction is 3 months. Conviction is only 3 months.
3 months.
And there is a 3 months. Cross cases, there both the cases has been filed. One by the accused person and another by the present informant in this particular case. Ultimately, petitioner accused has been convicted for 3 months.
3 months.
3 months. And there are a lot of contradiction in the evidence. I have annexed the copy of the evidence and cross-examination part of the IO as well as the informant. From the document itself, it is reflected that it is a case of doubtful. And because criminal case beyond reasonable doubt.
And I don't know, it's a matter of 2014 also.
Lordship can also take the clarification about the registry if Lordship wants.
Correct, that's what I just wanted to understand. Okay, we'll do one thing. We'll put it up at 2 o'clock. You take the registry by the notification to Lulu. We'll fix it up at 2. We'll take it up at 2 o'clock. Then we'll pass the necessary order. If the notification says that it's automatically go, then we can people take it up and we may fix it up in a short date.
Because all matters.
That is why I'm worried. 2014 matter.
Yes.
God bless.
2 o'clock we'll see.
34.
The criminal revision petition also.
But nobody is appearing. It is listed after such a long time.
2015 matter. Also.
Yes, 2015 and last date was 16/3/2017. Mr. A. Ahmed, who is A. Ahmed?
So 1 year conviction also.
He must have been already out.
Okay.
He must have been already out. Mr. Kotoki, Mr. I.A. Hazarika is not there?
Yes,
He is there. He's there in this case. This case is pending from 2015 and matter has been listed after 2017. So if he is there, then
I will inform him.
please inform him this item number 34. Item number 34. But nobody is appearing in this matter. So we'll pass it over. What is to be done? We'll fix it after some time. Okay. None appeared for the petitioner when the matter was called for. Though MS.SH Bora, learned APP is present for the state. For the interest of justice, let the matter be listed after 2 weeks.
I will inform him. This case, my lord, is a conviction under section 326, 324, my lord. Earlier, he was convicted on 327. The 307 was acquitted by the trial court, by the appellate court.
And this has also come after 2016.
Yes, it's after now.
After 10 years. I don't know how come the matters are being listed like this.
Actually, they have called.
You have to ask
And she have also not called for fine.
You have to ask for the registry and why.
Division of conviction is.
LCR is there, huh? Mr. Boyso, LCR?
LCR is there.
Some records are received. Yes, it has been received.
Then Mera may fix for hearing. But there some time for regarding.
You want to go through these records?
Like what means regarding injury report and all that, well, it will take some time.
Okay.
Because other parties or informant parties also there, they have.
Okay, right. I heard Mr. P. Kotoki, the learned senior counsel, assisted by so-and-so, the learned counsel for the petitioner. Also heard Mr. S.H. Bora, the learned AVP for the state. The TCR in the incident case has already been has been received. Full stop. Let the matter be listed for Mr. So-and-so for response number 2. Let the matter be listed for hearing after 3 weeks.
Yes.
After 3 weeks. We'll just come back in 5 minutes.
বেশি বন্ধ করে দিন।
36, the hearing.
Yes.
On the last occasion, that is a medical report was called for lordship, giving last chance the. That report we have received also. Huh? That report.
Received.
Moreover, I have also alleged here that statutory that notice under section 47 and 48 at the time of arrest was not served to the accused lordship. Because operation routine doing this. সিহঁতে নাহে নেকি এতিয়াৰে নকৰে ইনফৰ্মেঞ্চ সমন ইছ্যু কৰিছিলে
So his treatment is going on. They have referred him to GMCH that.
But he needs a surgery, lordship.
So I mean, they are going to take take the steps for his surgery or whatever.
I mean, kindly turn to page 7. I have specifically mentioned about the statutory provision has not been complied with.
That will see what is not complied with.
That is proper care they have stated, but no proper care has been taken, lordship. Once they admitted in the GMC, subsequently he was released, and now he has been suffering to complaining bleeding.
He has been given medication by the GMCH. He is taking medications. Only thing is surgery may be required, or they'll take the necessary steps for surgery also. That's what they have said.
Lordship, in this case, lordship, statutory provision is not complied with. There is several.
That we'll see. That we'll see. Just wait for a minute. We'll see.
Yes, lordship.
What statutory provision was not complied with? We'll see that.
Lordship.
What is your contention?
My contention is that at the time of he was arrested on.
Where is that page?
Page 17, lordship. That is the FIR.
No, where is your pleading? What statutory provisions have been violated?
Yes, lordship. It is page 7, paragraph 7, lordship.
Where is his earlier rejection order?
Lordship, that is at page 58. And actually 9. 59 operative portion.
No, whether this, in Guwahati High Court, his bail was rejected
No,
earlier,
no.
not rejected.
No. Earlier I have filed an application. There is some defect in the petition. That is why I withdraw.
So where is that?
Withdrawal.
That you have withdrawn, where is that?
I have made statement, Lordship.
But where is that order?
Order I have not annexed, Lordship.
Order has to be there.
Because it was withdrawn, I have made.
Withdrawn also, that has to be there. All the orders, whatever has been passed by this court.
But there is
should have
no
been
such
there.
that withdrawal order has been annexed.
No, any order, we cannot suppress anything, madam.
I have not suppressed, Lordship, because
Only statement will not do. That order, what has been there in the order has to be seen.
I have mentioned in my petition, Lordship. Earlier also so many cases we have mentioned.
Earlier it is different, madam. Earlier it is different, now it is different. Now just
Paragraph 7, Lordship, page 13. That a petition state a bail a petition being BA number so and so, because I have not annexed some of the translated copy. That is why I had withdrawn, Lordship. Which was withdrawn on 9/2 with a liberty to file afresh, as there were some defects in the bail petition. Translated copy I have not, I had not annexed with the petition, Lordship.
but 4748 has been served. 4748 has been served. Both the notices have been served to you.
I have not received any notice, Lordship.
Your signature is there, madam.
Nowadays, mechanically, Lordship.
Now, how can you say that? Now, we'll go by what? We'll go by this record or what? Something else. Probably you have not been properly instructed.
They have
all these
4748
have been given to you. Your signature is there.
Signature they can take in police custody because he was picked up on 6/8.
How then it will be served, madam?
Lordship, kindly.
No, how then it will be served? If you are saying that it's about only giving the notices, right? So once they give the notices, the signature has to be taken.
In different cases, Honorable Supreme Court will state that only giving the notice is not sufficient.
Then what is sufficient? Please tell me.
After that, he must know about the ground of arrest.
The grounds are
kindly turn to page
grounds are written here.
Lordship, kindly turn to page 70.
No, forget about we are concerned with these two.
There is some, yes, two, not only two.
We are concerned with the notices, right? So we'll have to go by the notices and what are the contents in the notice. If in the notice the grounds were given properly and that has been duly received by him, then it is a compliance of 4748. But if you say that there is no compliance of 4748, you tell this court.
Page 7, that FIR was lodged on 7/8, and he was picked up on 6/8, and his mobile was seized. That is annexure 2, page 21. Can you see, Lordship?
Your case is that 4748 notices were not served on
everything
him.
They must be complied. It is
Everything means what?
That is mechanically, Lordship, kindly see.
No, what is mechanically? You tell me.
This is the annexure 2. They have seized the mobile on the 6/8.
So
how they, without filing a FIR, how the police can seize the mobile on 6/8?
You place a case that police cannot seize the mobile phone before filing the FIR. You place a case. We'll look into that.
Today I cannot.
No, you don't have any case in this, madam. Now, if you have any other grounds, you tell me.
No,
but
I
that 47.
He is a student of. He passed out BSc, and now he He appeared in the joint admission test of masters.
See, madam, this.
And Lordship kindly turned to.
The 36 notice was, arrest memo was properly prepared. It was.
I have not gone through because they have stated that no notice has been given. That is why I am made the statement.
Correct. So you have not been properly instructed probably. We'll go by the record. We'll go by the record. 36 arrest memo was given to you. Signature of you. Please hear me out. 36 arrest memo was prepared. It was given to you, wherein the signature of witness is there. Your signature is there. So 36 complied with. Then 47 notice has been given to you with the grounds wherein your signature is there. Then 48 notice was given to the person nominated by you. His name is Pradeep Kumar Deka. And where his signature is there.
He also stated me that he has not.
His signature. Then I will go by what?
Yes.
I'll go with the records, isn't it?
Page 64, Lordship. That is the last order. The learned court below allowed him to appear before the joint admission test of the masters.
That is that.
And
So
accordingly,
he is a student, so he has been given those
Medical ground.
not medical ground. That was
Examination ground, Lordship.
examination ground, and he.
So he was allowed
He
those.
complied with the orders of the honorable court.
So
subsequently, he
is there a ground to leave him now?
Because
in a POCSO matter.
POCSO matter, Lordship can't then kindly see the statement of the girl and FIR. FIR kindly turn to page, Lordship, 19.
Yes, what is there? Page 19.
Is the FIR lodged by?
If FIR we have gone through, ma'am. We have gone through.
Compared with somebody, she went to some places. She did not know about that person. Whether it is believable, Lordship. I did not know about that person. Subsequently, I know him.
Very serious allegations against him.
Yes, everything is serious, Lordship.
So everything is serious then?
Everything is serious because it is a made out case, Lordship. Because
See, madam, you'll have to convince this court that all these allegations are false on the basis of materials, not with your submissions.
Then kindly turn to page 25. That is the statement of the guard. She is corroborated everything, but subsequently he covered his face at page 27. Last part, Lordship. I did not tell to file a case. At the time of video call, he covered his face, and for many days he did not disclose his actual name and identity.
That is the main clause.
Without covering, anybody can go with any person. And since 24, he is committing rape to that girl.
Madam, there are allegations of sexual offense, that to penetration several times. That is on record. That is on FIR. And that has been corroborated. We'll pass the order.
It is Annexure 7, Lordship, it is a retaliatory motive. One Bijuram Bora had conspiracy against a petitioner, Lordship.
Okay, we'll see how the conspiracy has been, if any case of conspiracy has been made out.
Yes, because that is filed before the Honorable Chief Minister in 2024. Thereafter, that girl also, that person was tutor of that victim girl.
Okay, charge has already been framed also.
Charge framed.
Charge framed.
But he did not
Tomorrow
appear.
is fixed for evidence.
Hmm?
Tomorrow is fixed for evidence.
Tomorrow is fixed for evidence. Okay.
He did not appear.
Regarding the Biju Bora, there is no such, only if your lordship sees the CM letter, lordship. Complaint to the CM.
Where is that?
There is nothing, no name is in it.
Paragraph 7, page 7.
Paragraph 7, page 7.
Yes.
Annexure 7, this is the FIR filed by the petitioner. Page 39, Lordship.
One second. What is that? Where is that? Para 7. Please read out what is that.
May I read also?
Hmm.
That a petitioner states that he has been falsely implicated by the informant in
connivance with
Sri Bijuram Purva, against whom the petitioner has lodged a complaint on 14th of 2024 before the Honorable Chief Minister of Assam for committing sexual harassment to a minor student of Morikaon district. Said Bijuram Bora was a tutor of the victim along with other students at Morikaon, had committed sexual harassment to a minor student, and on the basis of complaint of the petitioner before the Honorable Chief Minister of Assam, the police was compelled to register a case as Mikirbaha PS case number so under section 376 subsection 2 1/511 IPC Rapid section 8 of POCSO Act. On the basis of the state complaint, Bijuram Bora was arrested. In the case, charge sheet was filed and he has been facing trial before the largest special judge, POCSO at Morikaon. Said Bijuram Bora is a resident of Nagaon, thereafter shifted to Nagaon from Morikaon and started to teach the students as a private tutor who having put proximity with the victim and her family members. On a retaliatory motive, said Bijuram Bora in connivance with Jahuruddin Chaudhary and the victim lodged a FIR against the petitioner who is a resident of Morikaon district and the police of Nagaon PS without holding any procedure of law and serving any notice under section 47-48 of PNSS had burst in his residence and picked up the petitioner from his residence in Mikirbaha and so and detained him in his custody illegally. So it's a very totally vague statement.
How it is vague?
No connection with the present.
How it is vague, Lordship?
Page number 44, Lordship, their letter, which is addressed to the CM. There is no mention regarding this Biju Bora or did 50. How can she now connect, Lordship? My friend can connect with this case. May I read the? This is an email, Lordship, from Kobi Ranjan, Gmail, to Honorable Chief Minister, Assam. Subject: urgent request for intervention in rape case. Respected sir, I hope this letter finds you well. I am willing to bring to your attention a deeply disturbing matter that requires urgent intervention and action from your esteemed office. Recently, a 14-year girl was subjected to the online crime of rape not once but twice by her tuition teacher. The incidents occurred on 7th and 10th of June 2023 within the premises of the tuition center. This abhorrent act has left in victim unauthorized and in urgent need of justice and support. Further investigation into the matter has revealed alarming patterns of predatory behavior by the perpetrators. It has come to the light that the teacher on a history of targeting girls from strict households, particularly those who excel academically. This predatory behavior proposes a grave threat to the society and well-being of the young girls in our community. Sir, I urge you to take immediate and decisive action to ensure that justice is served in this case. Additionally, it is imperative that measures are in place to prevent such heinous crimes from occurring in the future. I humbly request the opportunity
You personally.
You personally discuss it, let us further then
So there is no name mentioned there.
Nothing.
No mention, but that Bijuram Boda, I have stated it here.
You have stated, madam, where can
And
you find out,
FIR was lodged
how can you connect this with Bijuram Bora?
Nothing. In the case, whatever is pending, that copy is also not. Who has filed this case? Only he has filed, so it is coming to connect with me. But I have never done any tuition under this. This is.
I have mentioned, I have made statement regarding that.
No, madam, you have not stated about Bijuram Bora in this complaint, correct? And the complainant's version is that she has not taken any tuition under this guy Bijuram Bora. Then how can you connect this?
There is no.
These two. And you have not also brought on record any document to connect these two persons.
FIR was lodged by the petitioner before the chief minister.
Correct.
That
So
was a
no,
registered.
FIR, we know FIR has been filed, an investigation has been ordered. But how do you connect this Bijuram Bora with this? We have not named anybody.
Yeah,
And the complainant is himself saying that like she did not take any tuition under Bijuram Bora. Do you think, madam, 15 years old girl will unnecessarily, I mean, in our society, unnecessarily, I mean, accuse somebody, that too, of this kind of offenses? Falsely, without having any reason.
Nowadays,
So that is a matter. So that is a matter of investigation, isn't it? So investigation will be done.
But there.
So the trial, madam,
Trial, but someone was issued several times, but they did not appear before the court, just causing delay of the matter.
Someone was not served. The last occasion, we appeared, but their counsel took, due to some medical ailments of the counsel, they took time. And this time they have received the summons. They will appear also. Why we will be delaying the trial in such a way?
Since December, notice was, someone was served.
No such order that we have violated the court.
Then non-bailable warrant of arrest was issued, then and again fixed on 26. ওলাইছে আজি ৰাতিপুৱা যিটো কৈছে সেইটোৱে গম informant against informant.
Against you non-believable or
Today morning only I spoke with them.
Also spoke.
Which is their order?
Today, how can lordship today morning?
If you say something, madam, before the court, then with documents you'll have to say. You cannot just make a passing remark or something like that before this court.
No, then lordship call for the.
Why should I call for the record? You are releasing. Then you should place in the court. Why you are not? Why you?
I can submit because
No, you can submit. You can submit, but
it
you
is
can.
not like that.
Madam, you can submit. I'm not saying you cannot submit, but you have to submit with the document.
How can?
If you do not have the document, then you don't submit. If you do not, you cannot substantiate your submission, then why do you are submitting? See, non-bailable issuance of, madam, issuance of non-bailable warrant is a serious matter. If you are alleging so, you should bring that document. Okay, this is the order.
Because lordship, the case was supposed to be listed on 29th. On that day, case was not listed. Today it has come before this honorable court. Previously on out of station, that is why we have taken time.
This is not done. This is not done. You cannot.
It is in the record.
You cannot just
of the court. How it is? He has submitted a non-bailable warrant was issued. Only he also submitted. I am also submitting.
No, this is your allegation, madam. You are saying that non-bailable warrants were arrested. So if you are saying, then you should substantiate it.
Today morning, I came to know about that. Nice one. Record চালেও দুখ লাগে ইস্যু ফ্ৰেম কৰাৰ পিছত কি মানুহে এপিয়াৰ নকৰে নেকি?
But you're submitting, there is something, because on tomorrow is the date for evidence. And there's.
আগতে পরে কথাই আছে আগৰ কেনেকুৱা হৈছে
So that.
ৰেকৰ্ডটো কৰোঁতে কৰিব মই ৰেকৰ্ড কৰিব নোৱাৰো এতিয়া
Yeah, case here.
So. Let's take them. Yes, sir.
Okay, we'll pass the order. We'll go through the case diary and pass the order.
Like.
Forty-seven.
May please, Your Lordship.
Yes.
My lord, hearing this case, the petitioner was arrested on 24/6/2025.
24?
6/2025. As on date, the petitioner has completed 336 days. The case is registered under section 126(2), 127(2), 74, 75, and 64. My lord, kindly come to page number 18. This is second bail application, Lordship. Earlier order, Lordship, I have annexed, that is at page number.
Page?
32. Relevant would be 33, paragraph number 3 onwards.
Yes.
My lord, may kindly come to the FIR, that is at page number 18.
Yes.
Dear Lordship, the age of the informant, that is the alleged victim, is 47 years, and the petitioner is Lordship somewhere 31 years.
Petitioner is?
31 years, my lord.
Ah.
The age of the alleged victim is 47 years old, Lordship. Page number 18.
Yes,
the
then?
FIR. Page
Then?
number 18 is the FIR. May I read it, Lordship? Small FIR.
No, I've read it, yes. Then what is your case?
My case is that, Lordship, here the charges were framed. My lord, may kindly come to page number 32. 32. Order dated 17/10/2025. I had preferred one bail application before the learned court below that was rejected on 17/10/2025.
Yes.
Last paragraph, in view of the above, as well as considering the nature of alleged offense, the prayer of bail is rejected. My lord, may kindly come to page number 31.
Yes.
Heard both sides. Charges are framed under section 126(2), 127 to 74, 75 twice, and then 64 of BNS against this, fixing 30-10-2025 for production and case management hearing. Thereafter, Lordship, 17 dates have gone by, 30, 10, 11, 11, like this, Lordship, 17. All the dates, Lordship, the same order has been passed. Accused Zubair Ahmed is produced before me from jail. He is further remanded to jail custody, fixing the case for production and case management hearing. Same order, Lordship, 17 dates. So, Lordship, my first line of argument is that, Lordship, this is not a case, Lordship, where POCSO is there. Section 64 is there. As on date, Lordship, 336 days. And Lordship, I'm ready to face the trial, Lordship, with any condition. Another aspect, Lordship, is earlier, Lordship, this ground was not taken. Page number 39, that is the, Lordship, arrest memo issued under section 36. The arrest memo was not signed by any witness. Page number 39 and 40. My signature is there, but attestation is not there. And regarding that, Lordship, I'm relying on a judgment by your Lordship, a judgment dated 24/2/2026, passed in BA number 25 of 2026, regarding the non-compliance of section 36. Basically, these are the two grounds, Lordship, on which I'm seeking bail. And Lordship, being an officer of this court, Lordship, I have another submission. So far as the non-compliance of section 36 is concerned, Lordship.
Yes.
Recently, Lordship, there is another judgment of our Honorable Court, Lordship, where it has been held that even if, Lordship, section 36 is not complied and if section 48 is complied, so, Lordship, the arrest will not be rendered as illegal.
What is that order? That's with you? That order is with you?
Yes.
Where is that?
But in the judgment dated 24th to 2000.
Madam, why I mean, this is happening, so many dates have been given, but there is nothing proceeded, 17 dates.
To that regard, Lordship, may I give a direction to the trial court for speedy trial?
No, I mean, 17 days, there is nothing has been done.
Lordship may call for its present status report.
Of the updated order sheet are there.
The order sheet is already there, I've seen that.
Lordship, POCSO is not there, Lordship, and kindly allow me to go
That is
on,
also
Lordship,
not registered under POCSO.
Yes.
First of all, that is not registered under POCSO. So that.
Correct, but 17 days without doing anything, only his presence is recorded, nothing has been done.
That effect, Lordship may give a effective order.
And only one accused person is there, Lordship. No co-accused, nothing is there. Only one person was there
This
in
is
the
the prime
FIR.
accused.
And Lordship, I am arrested. My Lord, may kindly allow me to go on bail, Lordship. I will face that trial, Lordship. And Lordship, there is clear violation of section 36 also, Lordship. In that regard, Lordship, I am relying on this.
37 and 40 is duly complied with and.
But in this judgment, there is no mention about like when this was given. You appeared or what? You didn't appear, somebody else appeared.
Yes, PS was done.
But here there is no mention of when this 48 was given.
Lordship, I am relying on the earlier judgment, Lordship, that is 24/2/2026, my Lord's judgment. Bail application number 25 of 2026, paragraph number 12 to 18, Lordship. Where my Lord was pleased to tell that, Lordship, violation of section, non-compliance of section 36, Lordship.
That I
Yes, Lordship. So, Lordship, on these 2 counts, Lordship, may kindly allow me to go on bail, Lordship, and I'm ready to face that trial, Lordship. May impose any condition, Lordship.
Lordship, if 47 and 48 is complied with, then 36, only the signature of relatives is not.
So there is I mean, we cannot change the legislature, can we? There is a statutory provision, why it has been brought in, why it has not been brought in. All these things are, I mean, it's on the part of the legislature to do it. Now, when these sections are inserted with some objects, and if those are not complied, we need to see whether those are complied with or not. As simple as that. And 62 says that it has to be strictly complied with. It's a question of arrest. Now, yes, there are one occasion comes that when at the same time when the arrest was made, 48 was also served. Then maybe, I mean, there may be some consideration that has to be looked into. But if 48 is not given at that point of time, then how can you say that like I mean, if you give it after 1 month, then can you say that like this 48 has been given, so arrest memo doesn't require his signature at all?
Otherwise. First, may kindly consider that part.
These are two, basically, these are the 2 grounds.
17 dates have gone, nothing has been done.
That effect, Lordship, will give the appropriate direction for speedy trial. Last sentence, Lordship.
My Lord, may kindly allow me to go on bail, Lordship.
The offense is serious in nature, Lordship. Otherwise, earlier rejected also by this honorable court.
Okay, we'll look into this and pass the order.
Yes, Lord.
Highly obliged. My Lord, there are 2 more judgments on 36. May I place it?
No, those things are, we are aware of this.
Highly obliged.
38.
May I please the Lordship?
Also, in the earlier occasion, CD was called for that we have not received. Lordship, kindly give us a date.
Okay, see there.
Another matter, your Lordship, fixed on 2nd of June, your Lordship.
Same affair.
Same affair.
The matter may
But
be,
but
the matters may be taken.
okay, let learned MSHH Board, learned APP appearing for the state, submits that CD in the instant case is yet to be received. Mr. R. Ali.
AM Khan.
Huh?
AM Khan.
AM Khan, the learned counsel, is present for the accused applicant. Full stop. Let the matter be listed on 2nd of June.
In item number, may I mention item number 36, Lordship?
36.
That has gone. 36, Lordship, a report was called for, that is medical report, that may be kept as a part of the report.
I'll mention about that.
Obliged.
39 order.
Though this matter has come up in the orders column, the service upon the respondent number 2 bracket 1, 2, 3, and 4 are completed located. Lord, you may kindly see order dated 18/2/2026 located.
The service is complete in the in right. Yeah, you are.
Else and them.
might not be filed in Upalatnama. Point number 2 might not be filed in Upalatnama. 2, 1, 2, 3, 4.
Earlier, Mr. S. Chakopati appeared for the respondent number 2. For the newly implemented respondents of, I think Mr. S. Chakopati will be here. We have informed him, actually we were supposed to mention this matter in the morning itself. That is the reason this one. We were supposed to mention this matter in the morning itself during the mention hour, but due to some difficulty, we couldn't mention it. We have already informed the council.
That is the Lawazima order.
Order dated, what may see, order dated 2012.
1 second, 1 second. Let me go through this. Sir, I heard Mr. So-and-so, the learned counsel appearing for the petitioner. Also heard Mr. So-and-so for learned counsel appearing for
1, 4, and 5.
1, 4, and 5. None appeared for respondent numbers 2A, 2B, 2C, and 2D.
Respondent number 2, we have informed him, Lordship. We have informed him to mention the matter, Lordship. He has given his consent in the morning.
I am asking you, who are the respondents? Respondent number A, 2A, 2B, 2C, 2D. None appeared for so-and-so, so-and-so. On perusal of the proceeding of Lawazima Court dated 18/2/2026, it is seen that service upon the respondent number 2A, 2B, 2C. It is 2A or 2-1?
1.
2 Roman 1.
Somewhere they write 2A, 2-1. You make it 2-1, 2-2, 2-3, 2-4. Has been completed. Full stop. Let the matter be listed for admission in usual course.
All right.
And I thought 40 Lordship may close this during the pendency of this petition, the matter has become effective. This matter has become
Item number
40. This is settlement of market for the period 22 to 23. The matter has become effective.
you are appearing for your name. What is your name?
Else and Lordship. Mr. Lenzo.
Mr.
Lenzo.
Lenso, okay. Mr. Lenso, okay. So this has become infractuous. No steps to you took in the matter, in this matter also. After 22, you have the instructions.
You have the instruction that this matter has become infractuous.
The period is already over.
Period is over.
Okay.
Proceeding with
Heard Mr. Lanso, the learned counsel for the petitioner, also heard Mr. MS so for the respondent. Respondent number? You are appearing for whom? 2, 3? You are appearing on behalf of PNRD as Datta. MS so on behalf of Mr. S. Datta, the learned standing counsel for PNRD department for respondent numbers 1, 2, 3, and 5. Full stop. Mr. Lanso submits that the instant case is become infructuous infructuous because due to lapse of time. Full stop. In view of the aforesaid, the instant petition is closed as infructuous.
41.
Lordship, in the last order, the Honorable Court direct us to file a fresh writ petition. So we filed the writ petition, and in the meantime, the respondent have filed the response.
You file an IA. IA for what? IA dispose of? Amended cost title. Okay, heard Mr. M.H. Amen. M.H. Amen. What is the name?
R. Ali on behalf of MSM.
R. Ali on behalf of he submits that in terms of the order. You have taken this thing, steps for service of notice?
There is no private respondent. There is no private respondent.
Okay. Submits that amended cost title, amended petition in terms of the order dated 3/12/2025 of this court has already been filed. Will the matter be listed for admission in usual course? What is this IA for?
I don't give the brief, Your Lordship. So senior is out of station.
Okay, IA is disposed of. Earlier on. Okay.
Okay.
42.
May please, Your Lordship. My lord, as per operational dated 3/2/26, my lord, we need to take fresh steps to the respondent number 6 and 7, my lord. No, I need some time to, my lord, take fresh steps.
You are Mr.
M. Islam.
Mr. M. Islam, the learned counsel appearing for the petitioner, submits that he requires some time to take fresh steps for service of notice upon respondent number 6 and 7. Prayer is allowed. Petitioner is directed to take fresh steps for service of notice on respondent number 6 and 7 by speed post within a period of within 3 days from today.
Can it be on Thursday? Because, my lord, I'll be out.
Within 3 days, you take steps.
Earlier.
What steps will not give you much time. Let the matter be listed after 2 weeks. Steps you take within 3 days.
Lordship, my lord, matter has become infructuous.
Matter has become infructuous for what?
Lordship, tender time is already over. Period is already over, Lordship, tender period.
Tender period is already over. You are appearing for the petitioner.
Lordship. B. Chaudhary is appearing, Lordship.
My lords, I appear for the ONGC, my lords, respondents number 2, 3, and 4.
So matter has become infructuous.
The period is not over. Perhaps they don't want to challenge this any further because the tender period and the subsequent awards, they are for a period of 4 years. We filed our affidavit, we've pointed out, my lords, there are certain preliminary objections also we
Tender is already going on.
So you don't want to participate,
They have allotted.
but you have instructions to withdraw this matter, right?
Matter may be closed.
Matter may be closed, but he's saying that
Means
period
there
is
is
not.
there is no interim order, Lordship, and they have allotted.
Yeah, we'll allow this. We'll allow them.
My lords, my lords.
So, yeah, Mr.
M.K. Sharma.
Mr. N.K. Sharma, the learned counsel. You have a wakalatnama in this case. Mr. N.K. Sharma, the learned counsel, appearing for the petition, submits that he desires to the instant petition. Mr. B. Chaudhary, the learned counsel, is present for ONGC. Respondent number
2, 3, and 4, my lords.
2, 3, and 4. Full stop. The matter is closed. Matter is dismissed as withdrawn.
I'm deeply obliged, my lords.
Caveat is caveat is there. Caveat is dispensed with. The caveat connected caveat is dispensed with.
44.
Deeply obliged.
May I please your lordship? Service of notice to the respondent number 4 is completed.
I appear, Lordship. I did the respondent 4. We need some more time.
Okay, so and so the petitioner also heard Mr. B. Dekar, the learned counsel appearing for
Respondent number 4.
respondent number 4. Respondent number 4. Others already they are appearing.
Notice was issued for him on last order, Lord. Service was awaited on last order. We are after that.
Okay. And let the matter be listed for admission in usual course after 2 weeks.
Admission.
45.
Lordship, as per the office note, my lord, no answer of notice is returned, my lord, in respect of respondent number 10, private respondent. Lordship, I may be allowed to take dusty service in the meantime, Lordship. On the sole private respondent, respondent number 10, Lordship.
To take fresh steps.
Lordship, I may be allowed to take dusty service, Lordship, because twice already I have taken steps twice, Lordship.
Let him do it. Heard Mr.
MM Zaman.
Jaman, the learned counsel for the petitioner. Also heard Mr. J. Handig, the learned state learned advocate for the state respondent.
1 and 5.
1 and 5. So it is 1 and 5. You all are also there? You take their names also. You give your slips. It is seen from the records, including the office note dated 25/2026 that though several steps for though notices were sent twice, how the same came back with however the same. However, neither the AD nor unserved notice came back. In view of the aforesaid, the learned counsel appearing for the petitioner submits that he may be allowed to take service of notice on respondent number 10 by way of dusty mode. Full stop. The prayer is allowed. The petitioner shall take the steps for service of notice through registry by dusty mode. Within a period of 1 week and thereafter file an affidavit in proof of service of notice on respondent number 10. Let the matter be listed after 10 days, after 2 weeks.
Obliged, Lordship.
May I please, Your Lordship?
Yes, madam.
Lordship, I want relief may be granted to the review applicant in view of Lakeshwar Das versus Union of India.
What is there?
Here, the entitlement to the invalid pension is one thing, but the entitlement to the pension heirs is one thing. The next question to be considered is what sort of relief can be granted to the petitioner, considering the fact that he approached this court after 28 years from the date of his retirement. One of the exceptions to the said rule is case relating to continuing wrong, where a service-related claim is based on a continuing wrong. Relief can be granted if there is a long delay in seeking remedy. With reference to the date on which the continuing wrong commences, of such continuing wrong creates a continuing source of injury. But there is an exception to the exception. If the grievance is in respect of any order or administrative decision which relates to or affect that several others also, and if the reopening of the issue will affect the settled rights of the third parties, then the claim will not be entertained. For example, if the issue relates to payment or refixation of pay or pension, relief may be granted in spite of delay, as it does not affect the rights of the third parties. But if the claim involves issue relating to seniority or promotion, etc., affecting others, delay will render the claim stale and doctrine of leges. Limitation will be applied. Insofar as consequential relief of recovery of heirs is concerned, the principle relating to recurring successive wrongs will apply. As a consequence, the High Court will restrict the consequential relief relating to errors normally to a period of 3 years prior to the filing of the writ petition. So, Lordship,
But where is your right of pension in this case?
Lordship, here
your service was not regularized.
As per the
your service itself was not regularized. You worked only as a part-time worker.
yes, I'm not seeking regularization. I'm seeking for pensionary benefit.
So if you are not regularized, how will you get pension?
So, Lordship, for the purpose of pensionary benefit, the case of the applicant may
pensionary benefit. First your service has to be regularized. Then only pension can be granted.
So there is no bar.
In the other case, the facts may be different. Facts only because 28 years of delay, but he is eligible for pension. Then
Yes,
that can be considered. But in your case, you are not regularization.
Kindly grant direction. Kindly consider his case for pension benefit.
No, pension when a person gets pension when
after
a master worker gets pension.
Yes, Lordship.
Where under which law you get pension? Your service itself is not regularized to get pension. So where is your right to get pension?
For 35 long years in service.
Whatever it may be, then why didn't you go to the court at that time for regularization? If you are not regularized, how will you get pension?
Your Lordship, we have approached the respondent authority seeking for.
I understand, but since your job was not regularized at all, how will you get pension? You are not eligible for pension. If you are eligible for pension and you have approached the court little bit, in a delayed manner, then it could have been considered. But your case is, there is nothing on record that your job has been regularized.
Lordship, the applicant was never had that knowledge to approach the court.
So what can be done by this court?
Yes, Lordship. So,
Your service itself was not regularized. Then where is the question of pension?
Lordship, for the purpose of family pensioner benefit only.
Pensionary benefit only you will get when your service is regularized, when you are in a service substantive post.
Lordship, kindly grant his service.
It cannot be granted just like that. Yes, government side.
No, Lordship. This cannot be done, Lordship, since the petition was in fixed paid, Lordship.
Yes.
Case cannot be considered, Lordship.
Your case cannot be considered because you do not have any right to get pension.
No, Lordship,
First your service has to be regularized. Then only you will be eligible for pension. That too, we'll have to see whether the pension rule is there or not. It gives pension or not. Your rules gives pension or not. Then only it will be decided. And your service itself is not regularized in this case.
Lordship, kindly grant me some time to see proper.
Okay, you come up with something that then we'll see. Then we'll see on the prayer of the counsel appearing for the petitioner. Let the matter be listed after 2 weeks. You come up with something. See, your thing is that you have not been given pension, though you worked for 35 years. But 35 years you worked as a master role, in a master role. So your service was never regularized. So how will you get pension? Okay, you come up with, I'm adjourning it for two weeks. You come up with something if you have some materials.
Yes, Lordship.
Okay?
Yes, Lordship. Much obliged.
Okay. Let it be listed after 2 weeks.
Obliged, Lordship.
Let me fix up 2 weeks. Fix up to 2 weeks, in the prayer of the council.
I can free.
এইটো গোস্বামী মেটাৰটো নহলে বেলেগ এটা ফিক্স কৰি দিম যদি পাৰা যায় বহি থকাতকে 1 second, I'll just Mr. Goswami. Sir, notification. So, that notification is there. So though it was heard substantially, so it has to be released as per this. Release. So we'll fix up another date. We'll take up on the date now. When do you want?
Any day, also.
Any date means your company.
I have no instruction with my client. I have no telephone connection also.
Then
Lordship, I want to finish this matter because it was lying with me, Lordship. It is a burden for me also, for the court also.
Next week we'll take it up. Okay, on the joint prayer of the learned council appearing for the parties, let the matter be listed in the next week.
Not on 6th, Lordship. Not on 6th or 5th.
Let the matter be fixed on 4th of June. Third is a non-hearing day. So 4th is a hearing day. 4th will be better.
Hearing day will be better, Lordship.
4th will be
Because
better.
it will not take more time, Lordship. It is already a covered case.
4th will fix 4th. 4th you have some problem. 4th will do it. এখন রাখি দেবো বেশ এখন রাখি দেবো So 4th will take it up. So I have gone through these writ petitions. There are certain things are there.
Your Lordship, I have prepared a
Ah,
convenience.
have you
volume.
prepared anything? I have, last time I requested you.
Why not, I'll submit it.
You submit. I mean,
Yes.
there's nothing more to.
Your Lordship will kindly allow me 15 minutes, Your Lordship.
Why 15 minutes? 5 minutes?
I'm a bit slow, Your Lordship.
No, you are fast. You are fast. You are quite fast.
Your Lordship, this is a convenience volume. Your
But this
Lordship.
is
Convenience volume. Your Lordship.
not on citations. Huh?
No, what I'm saying, Your Lordship, all these citations has been placed before Your Lordship.
Citations are there in the.
Citations are there, some rules are there, and some new citations which I have relied on. These are there. This is a convenience volume which will help Your Lordship, Your Lordship. I believe that.
Mr. Bora also submit one.
So let Mr. Bora submit, then I'll submit.
No, but Bora doesn't have any submission. You make submission. He already finished.
Your Lordship will kindly turn in that case. Your Lordship will kindly turn to volume 1, page 1.
Okay, bro, I'll take up this too.
Yes, Your Lordship can. Your Lordship, I have not annexed all the documents. That doesn't mean I have suppressed anything. Your Lordship can always go through if there is something required to be done, if Mr. Bora can point it out.
No, correct. No, we are not saying that. I'm just saying that whether we need to refer to this or that. Yes, volume
1.
Yes.
Now, Your Lordship, the points of formulations at page 1.
You give a copy to Mr. Bora also.
I have given a copy. The rest of the citations is written there. He can always refer. And if you want a soft copy, I can give him right now. Page 1, Your Lordship.
Yes.
That are the formulation of issues for consideration for Your Lordship.
Yes.
Whether the petitioners are eligible, qualified for promotion to the 83 numbers of vacant post of sister tutor, PHN academic side of the nursing. Whether the letter bearing dated 11/11/2024 issued by the DHS Assam to all the joint directors and other districts of the hospital as well as the head of the hospitals throughout the state of Assam seeking the ACRs of the petitioners was with the intent to promote the graduate BSc nurses to the vacant post of 83 numbers of sister tutor PHN. Number 3. Whether in spite of recommendation of the DPC to award promotion in 2 ways process for the post of ward sister, ward in charge, nursing sister, OT sister, such and such, having GNM diploma for the academic and PHN, that is for the clinic, from the staff nurse having GNM, and for the academic from the post of staff nurses having BSc, respectively in orders of seniority cum merit, and therefore having recommended. Your Lordship, my specific pleaded cases I have been recommended. That I'll justify. Can the director on its own restrain the petitioners from being promoted to the post of sister tutor by not issuing the promotional orders? The next page, Your Lordship. Whether the recommendation of the minutes of the DPC dated 16/12/2024 can be tinkered with by the director, having recommended. Now the next, whether the director is empowered to implement a part of the recommendation of the DPC and does not comply with the other recommendation of the DPC in absence of any challenge to it. Whether the long-standing practice of preparing 2 separate zones of consideration for GNM, that is diploma nurses for the post of ward in charge, sister tutor, nursing sister, OT sister on the clinical side, and a separate zone of consideration for the BSc graduate nurses for the vacant post of sister tutor PHN on academic side, which has been followed since long as per the rules of 1991 and the Nursing Council Act of 1947, can be given a go by the DHS Assam on his own whims. And the last, whether the post of sister tutor PHN in the GNM nursing school can be kept vacant, causing loss to the public interest and thereby leading to collapse of the entire health system in the state of Assam by not promoting the petitioners. Now, Your Lordship, this is the gist. In this instant case, writ petitioners, there are 98 numbers of petitioners who are all BSc graduate nurses. They are all appointed in the year 2018, some in 2017, and therefore, in terms of Rule 11 of the Assam Nursing Rule 1991, are eligible to be considered for promotion to the next higher cadre of sister tutor PHN. They have been suitably considered for promotion and were recommended for promotion by the DPC, which is evident from the minutes of the meetings dated 16/12/2024, However, in spite of having recommended by the DPC to promote the petitioners to sister tutor PHN, the DHS Assam is not issuing the promotional order. That is my precise case. Now, Your Lordship, all the documents which I have annexed, here I have annexed as a convenience volume, and those documents are in the page number which of the writ petitions I have annexed. Your Lordship will come to page 5.
Yes.
These are the submissions that having called for the ACRs and suitably recommended by the DPC in the minutes of the meeting dated 16/12/2024, the DHS Assam cannot on its own deny to issue promotional orders with respect to the petitioners to the next higher post of sister tutor PHN. In the instant present case, the petitioners are BSc graduate nurses who were appointed in the year 2017 in terms of Rule 11 of the Assam Nursing Rules 1991. They are all eligible for promotion to the post of sister tutor PHN, which is an equivalent post of ward in charge, and both are equivalent posts. That the petitioners are graduate nurses and receiving a grade pay of 8,700, whereas the staff nurse having diploma are receiving a grade pay of 6,800. There is a very major difference in the grade pay also, Your Lordship, and that is visible from the ROP, Your Lordship. The promotion to the next higher cadre is to the ward in charge, sister tutor PHN. They are admittedly two streams, the clinical and the academic. The GNM
But
nurses.
this is, Mr. Singha, we are aware of this.
Right.
Facts, right? And you wanted to place what? Which record? Which case?
Yes, Your
cases?
Lordship.
Let's go for the, because we have already heard you and we are aware of the facts.
Yes, Your
A
Lordship.
specific point that like you have left out, not placing before this court, you just place it, or some case laws that you want.
Yes, I'll do that. I'll cut it short, Your Lordship. Your Lordships will kindly just a minute. Itu putusik, dari itu. Your Lordship will come to page 187. Convenience volume, page number 2.
Convenience volume, part
CV2.
2. Part 2.
No, part 1, CV2. Page number is CV2. I have written it, Your Lordship. After page number 13.
CV2.
Yes. After page number 13, it will come, Your Lordship.
CV is like a continuation page.
CV is convenience volume. Yes, it's continuation. After page number 13, it's CV1, CV2. I've written in that.
This is like page numbers.
Yes, Your Lordship. These are page numbers. Has Your Lordship got it? CV1 or
yes,
CV2?
yes.
CV1 is the letter. It is the letter wherein our ACRs were called for. So my vested rights get crystallized here. For being promoted, gets crystallized. For being considered for promotion, I'm sorry, Your Lordship, it gets crystallized by this letter. Now the second letter, Your Lordship, second page. Your Lordship will straightway come to page CV3.
Yes.
Serial number 4. The Departmental Promotion Committee decided to award promotion in 2 ways process for the post of ward sister, ward in charge, nursing sister, OT sister, PHN, that is clinical side, and academic side for the seniority list of staff nurse published on 2011-2024. In the clinical side, for the post of ward sister, ward in charge, nursing sister, OT sister may be filled up from the post of staff nurse having GNM. And in the academic side, for the post of sister tutor, PHN may be filled up from the staff nurse having BSc nursing. Your Lordship, based on this recommendation, 96 people have been promoted. GNM nurses have been promoted to the cadre of ward in charge. So, Your Lordship, a submission was made before this honorable court saying that no recommendation was made. Now, can my friend take the pain of showing where is the recommendation of the for promotion of the GNM nurses, for which the promotional orders have been issued.
You're saying that he cannot show any separate recommendation.
Nothing. This is the recommendation, Your Lordship. And based on this, I have demonstrated before Your Lordship, before this honorable court, that 96 people have been promoted. There is no quarrel to that.
So there is no separate recommendation. This is
This is the only recommendation.
If there is any recommendation, then this has to be the recommendation.
Yes. And based on this, we have issued the promotional orders. That is on fact, Your Lordship, based on this recommendation. So now you go and take a U-turn and say the director on its own says that, no, we will not promote you. So where is the authority to
decided to award promotion to in two-way process?
Yes, that's a clear finding, Your Lordship. In two-way process, no doubt about that. So how will you fill up those posts? It's an admitted fact, which you have been doing since 2017. Can you deny me now, right, which has crystallized since 2017? That Supreme Court has answered. I'll come to that. Now, Your Lordship, they are speaking of eligibility. As regards the eligibility, the Supreme Court has answered in
eligibility. I don't think they have any issues.
Right. Now, eligibility with respect to the post, eligibility and post and seniority, if there are three things. Somebody may be senior to me, no doubt about that. You have to consider him. But if that person does not have the requisite eligibility in terms of qualifications and experience, whatever is laid down in the rules.
No, there is no dispute that you have the eligibility.
Yes. So therefore, the senior person has to lead the way for out. That judgment I have already placed before Your Lordship. And in that case, Your Lordship, now there is a long-standing practice. I have placed that also, that the long-standing practice has taken the shape of the rule now. And the DPC has done it in 2017, 2021, and this time also. Your Lordship,
Which are those documents that you have annexed about the long-standing practice? Earlier they have done so.
Yes, Your Lordship. TV 55. It was done in 2017. I have annexed in my additional affidavit. It was done in 2021 also.
Okay, so CV 55, let's see how they have done it.
Yes, Your Lordship will come to CV 56 now. It starts from there. Serial number 2. The promotion committee decided to prepare two zones of consideration in the ratio of 1:4 from the common gradation list of staff nurse for promotion considering the clinical and academic sides of the incumbents. In this regard, for award of promotion to the post of ward sister, ward in charge in clinical side, the incumbent must possess a GNM diploma, BSc nursing, post-basic BSc nursing. For award of promotion to the post of sister tutor PHN in the academic side, GNM training school, the incumbents must possess BSc nursing, post-basic BSc nursing. The promotion committee observed that in the prepared list of the first zone of consideration with the strength of 1040 for 260 numbers of vacant post of ward sister, ward in charge, sister tutor PHN, only one eligible candidate was found suitable for promotion to the post of sister tutor PHN. Therefore, the promotion committee unanimously decided to extend the zone of consideration from the common gradation list up to the number of 236 only with the requisite numbers qualification for filling up the 59 numbers of vacant post of sister tutor PHN. So they have done it then also. And the next page, Your Lordship, CB 57 and 58. It is the list of all those ward in charge, that is the clinical side, who are seniors to us, and page CB 59. Your Lordship will kindly see Annexure A7, I have written it. Annexure A7 indicates the Annexure A7 of the additional affidavit I have filed. The old page number is also written there, 370. So this is the list of all those persons who have been promoted. And I have annexed another list of 2017 also in the additional affidavit. I have not annexed here. That process was followed in 2017 also.
So you are saying that like earlier there were two zone of consideration. This time they have made only one zone of consideration.
Yes, Your Lordship.
And earlier occasions, because in 1:4 ratio, there are not sufficient people in the zone of consideration. So they have extended the number of zone of consideration, or they have expanded the horizon of zone of consideration.
Right, Your Lordship. Because a statute, the 1991 rules, and amended in 1998, I'll submit with all fairness that the rules does not say that you cannot do that. The rule says that you have to follow INC. Now, when you go to follow the National Nursing Council Act, it says that one has to be BSc for being tutor. So definitely it is implied that it has to extend. You have to select the right person for the right post. And that's what Your Lordship and Suresh Nathan.
But they have not promoted anybody who doesn't have qualification in those posts.
Fine. They cannot also.
They cannot do, and they haven't done also.
Right. But the TPC recommendation is there in my favor, equally in the favor of all those persons. They have not done it. Now, I could have understood if there was a challenge to that. If there was a challenge to the recommendation of our recommendation made by the TPC, I could have understood well that yes, fine, there is a dispute. Now, why, in spite of these recommendations, requirement in the health department, somebody on his own, against the public interest, against collapsing the health department, does not want to promote us? And he goes and says that we will appoint you on ad hoc basis. Supreme Court on 21st of May says no business of all these things. That judgment of Upen Das, which was passed by Honorable Justice Ujjal Bhuiya, that was reversed by the division bench, and that went till the Supreme Court. So Supreme Court passed the judgment on 21st of May, wherein Honorable Supreme Court says this business will not do. When the persons are there to be appointed, you have to appoint them. You cannot do this ad hoc business because ultimately they have to be regularized. So tomorrow again there will be a set of writ petitioners before this Honorable Court flooding with writ petitions saying that you please regularize in terms of this judgment. The Lordship will not allow those things to happen. Now your Lordship will kindly come to page 241, page 126 of the
Yes.
This is para 15. Your Lordship will come down below. I have referred it, but in spite of that, I'll just touch it, Your Lordship. As Your Lordship got it from down, a person must be eligible for promotion. 1, 2, 3, 4, 5.
Yes, I got it.
A person must be eligible for promotion having regard to the qualification prescribed for the post before he can be considered for promotion. Seniority will be relevant only amongst persons eligible. Seniority cannot be substitute for eligibility, nor it can override it in the matter of promotion to the next higher post. The rule in the question which prescribes an uniform period of qualified service cannot be said to be arbitrary or unjust or violative of Article 14. So they are speaking one thing, seniority. This has nothing to do with this. They only want to block this promotion for his self-vested interest. The Supreme Court.
That's what you are saying, that like seniority should be, seniority has to be accounted amongst the equals.
Yes.
Because we are not equals because our degrees are different.
Yes.
Our eligibility criteria are different.
And most importantly, the post wants me.
But they are saying that like, no, I mean like by this High Court also it has been stated that it has been laid down that only one seniority list can be made.
Yes.
Now the mechanism, how to do it, they are not aware of.
Your Lordship, I'll come to that.
And they are not doing it.
I'll come to that. That is distinguished. Your Lordship, we are not saying that 2 seniority list has to be prepared. We are saying 2 zone of consideration.
That's what like what they have done earlier. They have done 2 zone of considerations. This was one list only. But they have made 2 zone of considerations for these 2 different posts because qualifications are different.
Right.
So since the qualifications are different, you cannot make 1 zone of consideration. That is the argument.
Right, Your Lordship. And Your Lordship, ultimately, this 2 zone of consideration will be in the cadre of staff nurse. Now, when they get promoted to the next higher cadre of ward in charge or sister tutor, that gets merged into one gradation list. I cannot say prepare a separate gradation list for me, neither they can say. So that is not the case. And what is 3069 and 6968? I'll distinguish it, Your Lordship. Now, Your Lordship, Your Lordship will kindly come to page 9 of my convenience volume. Down below, Your Lordship.
The petitioners having recommended.
The petitioners having recommended thereafter subsequently cannot be denied the promotion on some fresh grounds which did not exist at the time of the recommendation of the DPC. Your Lordship, to this I would like to place two judgments. Your Lordship is aware of it. The petitioners having recommended by the DPC in the minutes of the meeting dated 16/12/2024 and thereafter the respondents cannot deny on some fresh grounds which did not exist at the time of the recommendation. The Honorable Apex Court had categorically stated public orders publicly made in exercise of the statutory authority cannot be constituted in the light of explanation subsequently given by the officer making the orders. Your Lordship will kindly turn to page 137 of the CV with this respect. That Gordon Das Bhanji's case, Your Lordship. The DPC recommended me. There is no complaint from the DPC. There is no complaint from any authority. DHS comes up with the new orders, Your Lordship, now. So the Honorable Supreme Court has said in para 13. Has Your Lordship got it?
Para 1-3.
1-3, Your Lordship. An attempt was made by referring to the commissioners to show that this was really an order of cancellation made by him and that the order was the order and not that of the government. We are clear that public orders publicly made in exercise of the statutory authority cannot be constituted in the light of the explanation subsequently given by the officer making the order of what he meant or what was in his mind or what he intended to do. Public orders made by the public authorities are meant to have public effect and are intended to affect the actings and conduct of those to whom they are addressed and must be constituted objectively with reference to the language used in the order itself. Your Lordship, the DPC has been constituted under the act of the statute, under a statutory authority. They have recommended me. On the basis of that recommendations, the ward in charge were promoted. We are left out. So there, the promotion was given effect to in respect of the ward in charge based on that column 4, which I have read, Your Lordship, just now. And there was no separate recommendations. Now, can you turn around and say, no, that was a wrong order. We don't intend to promote them. Your Lordship, and the next judgment is Mohinder Singh Gill. That is CV 157.
I'm aware of this.
Your Lordship, I'm obliged, Your Lordship. So that also says the same thing. A validity. The second equally relevant matter is that when a statutory authority functionary makes an order based on certain grounds, its validity must be judged by reasons so mentioned and cannot be supplemented by a fresh reasons or in the shape of affidavit or otherwise. Your Lordship, in the affidavit also, they have not stated anywhere that we cannot be promoted. They have not stated anywhere that DPC has not recommended. This is simply a submission made. Now, Your Lordship will come to CV 260. Oh, sorry. Page number 10 of my written submission. E, legitimate expectation, Your Lordship. Has Your Lordship got it? Legitimate expectation and vested rights accrued in their favor of the petitioner to be issued with promotional orders for the post of the sister tutor. Your Lordship, I would like to say that you called for my ACRs. You recommended me in the DPC. So my rights that I have acquired a vested rights which got crystallized in the DPC and therefore I have a legitimate expectation to be promoted, plus in view of the fact that it has been done since 2017. So to that effect, Your Lordship, I would like to refer to page 260 of the CV. A judgment I have annexed, Your Lordship. Has your lordship got it?
Yes, yes.
Para 115 of page 216. In the aforesaid context, we may make a reference to R versus IRC such and such, where Lord Justice of Appeal Thomas Bingham, while invoking fairness as a rationale for protecting legitimate expectation, expressed the following: if a public authority so conduct itself as to create a legitimate expectations that a certain course will follow, it would be unfair if the authority were permitted to follow a different course to the detriment of one who entertained the expectations, particularly if he acted on it. The doctrine of legitimate expectation is rooted in fairness. So everything your lordship has on the one occasion has raised a query put to me that whether in a service matter can there be legitimate expectation. My answer is yes, of course. Your actions from 2017 to till date, plus the statutory authority, plus the INC guidelines, coupled with the recommendation of the DPC and my calling of the ACRs, presented, recommended, and one batch has been promoted. When it comes to me, you are not doing it. So that creates a legitimate expectation because
how you have altered your position
who your lordship?
Because of this recommendation, whether you have altered your position,
They have,
which cannot be altered again, re-altered later on.
now the
See, legitimate expectation, one criteria, one primary criteria is that there is some order passed or there is some action or inaction by the government.
Right, your lordship.
And because of that action and inaction, you have altered your position. Right? And now, since you have altered your position, now you cannot re-alter it. So legitimate expectation is something wherein on the basis of certain order, government order, action, inaction, you have altered your position. Now they are taking a different course. Now you cannot alter it. So that is, I mean, then you have a case. I'm just discussing. I'm not saying anything. Then you can say that I have already, because of this, I have already altered my position. So I have vested right there. But in your case, how you have altered your position?
Your lordship, I would like to say that of course my position is not altered in that sense. But
so that is the principle why it is basically
not applicable.
basically stated in service law
It is not
that it is not applicable because in service law you do not alter your position.
I'm sorry, your lordship. I was trying to develop an argument.
That's perfectly right. You are developing it perfectly right.
But I was
we'll have to look into it. We'll have to look into it.
What I wanted to actually say is that your lordship submit before your lordship is that the DPC has recommended me, and now you say that I'll not promote you. One gentleman he comes and say I'll not promote you. I'm not issuing it. And most importantly, that gentleman has not said anything against me, simply not issuing the promotional orders. He is not coming up with any administrative orders because he cannot. It was a unanimous decision of the DPC. In that view of the matters, can you go back and say that, of course, if I would have been issued with what I feel I might be wrong, that if today the recommendation of the DPC would have been given consideration, I would have been promoted. So I would have been in a better footing because thereafter some more people are promoted for ward in charge. Now they are seniors to me. So I am losing my seniority also because of this inaction on the part of the director. So to that extent I was trying to say. Anyway, I leave it to your lordship to that extent. Now the next case, your lordship, is 3069, page 11.
3069
of 2018, which my learned friend has said that
I didn't get it. What 30?
Your lordship will turn to page 11 of my convenience.
Page 11, yes.
Not convenience volume of my, sorry.
Page 11.
WPC 3069 of 2018, the writ petition, which my learned friend has referred to, saying that I have filed the petitions and all those things. I'd like to clarify and distinguish it in terms of the present facts. Your lordship, it is there only, your lordship.
It is there.
Yeah, it's there, it's there. Your lordship will first turn to page 11. I have annexed it. I have obtained the certified copy and I have annexed it.
Yes.
The issue in the lease was twofold. Firstly, unauthorized publication of two gradation list of the incumbents one for the clinical and one for the academic in the same cadre of such and such. And secondly, the illegal action in only considering and promoting the ward in charge to the next higher cadre, thereby ignoring the sister tutor PHN for promotion in spite of being similarly situated. Your Lordship, what was the case about 3069? 3069, the writ petition was filed, of course, by a association. Now, the dispute in that case was, there are two gradation lists. One gradation list was of the ward in charge.
So that they cannot do that.
And one gradation list was of the sister tutor, which they admittedly cannot do. Secondly, the ultimate challenge was the promotion given effect to the next higher cadre was of the assistant matron. So they considered only on the people on the clinical side, that is the ward in charge. They were given the promotion, in spite of the fact that some of the members, maybe some of the members of the academic side was also eligible. So there was one gradation list in the cadre of sister tutor ward in charge.
So academic side was also eligible for system entry.
Yes, Your Lordship. We are eligible for both.
Both.
Yes.
So, but in spite of that, they have not given. They have given only given those people who has those diplomas.
Yes, they have not considered. Forget about not given, not considered. So that was the case, that you have considered only the people on the clinical side and given them the promotion. Fine. But you should have considered these people also because
they are also eligible.
They were eligible.
They were eligible and they were in the gradation list also.
Yes, that was the case. So this is clearly distinguishable. And what is my case? My case is twofold in this writ petitions. I have been recommended by the DPC. You promote me, please. And secondly, and most importantly, for the post, there are vacant 83 numbers of posts. I am the only persons. We are the only persons who are eligible. You cannot bring somebody from outside. So therefore, you have to promote me. So that was the case, Your Lordship. And I have annexed the orders also. I can...
And that's fine. I have seen that.
I have annexed the orders also. And Your Lordship will kindly see paragraph 4. Your Lordship may just note it down. Paragraph 4, 6, 7, 8 are the facts of the case.
That case.
Yes. And Your Lordship will just want to point their affidavit in opposition. What stand they came up? That is at page 355.
355 of this volume?
CV, volume 2, Your Lordship.
Yes.
Para 8. So there was out and out an illegality. Has Your Lordship got it?
Yes.
That as regards the statements made in para 7 of the petition, your deponent states that the promotion committee decided to prepare a list of 88 numbers of incumbents from the panel list of 88 eligible ward in charge for promotion to the rank of assistant matron, eligible for promotion to the next higher cadre, that is assistant matron on the basis of merit as per the seniority and satisfactory ACS as per such and such rules. And accordingly, promotions have been made. Accordingly, for the time being, 70 ward in charge have been promoted to the higher post of assistant superintendent, deputy superintendent, etc. If the ward in charge are not promoted to the post of assistant matron and assistant nursing superintendent, deputy nursing superintendent, then their promotional avenue would be virtually blocked, which is not justified. Who is he to take a call on this? My qualification justifies me for promotion to the academic as well as clinical. And their qualification justifies for the promotion only to the clinical side. So the director felt mercy for them and said, no, I am promoting and considering and promoting only these people, leaving out rest aside because they are only, their promotion scopes are very limited.
Correct.
So the court interfered with, nothing doing like that. Now, Your Lordship will turn to page 12. This is the last submission. I will not bother Your Lordship anymore.
Yes.
WBC 6th and 6th of 2024. This was a case wherein a decision was taken by the DPC to allot 70% of the PHN post to the A&M nurses. Now, who are the A&M nurses? Your Lordship, the matter was listed today. Your Lordship has a grip on this. A&M nurses is a certificate course. This is an entry level, just like staff nurse, this is also entry level and their grade pay is 6,200. Whereas in the staff nurse, there is two grade pay, 8,700 for the graduate, 6,800 for the GNM. So their grade pay is lower. That is a certificate course of 2 years. Now these people, forget about this ANM, even the GNM nurses are not eligible to be promoted as PHN and sister tutor, as is very evident from this case. So a decision was taken to allot 70% of the PHN post to the ANM nurses.
ANM nurses.
So that was put to challenge because they didn't have the eligibility. And that was challenged by an association. Of course, Rinti Boisho, who is a petitioner number 1, also happens to be the secretary. So that was filed by Rinti Boisho in the capacity as a union, not in individual capacity. Rinti Boisho has filed this case along with others because she has been denied her promotion by the director. And that was a case wherein the association came up just like 3069, saying that those people are not eligible. How can you promote that? So these two facts, which my learned friend was trying to impress upon this honorable court, does not fit in my case. And to that extent, I would like to place the LHV curriculum, Your Lordship. The LHV, the Lady Health Visitors. Your Lordship will turn to the second volume, page 463. Page 463. It starts at 462.
Yes.
This is the syllabus and regulation for the health supervisor female course. That is the LHB. Now your Lordship will come to 463. Sir, Madam, I am to say that the Nursing Council at its meeting held on such and such have approved the revised syllabus for the health supervisor. That is the curriculum of the promotional training of auxiliary nurse and midwife, and resolved to write to the State Nursing Council to conduct examination. Now page 464. Revised curriculum for the promotional training of auxiliary nurse and midwife. Duration of the course 6 months. After the training of the auxiliary nurse midwives working in the community, will be able to perform the role of the function of the health supervisor female. So the promotional post for the ANM nurse is LSV. After the completion of this course, once they are appointed as ANM and rendered their service for 5 years, they can undergo the 6-month certificate course.
I understood this.
So now I'd like to refer last 3 judgment, Your Lordship. I think those judgments have been given in loose.
Yes,
Sorry,
yes,
Your
yes.
Lordship.
Yes.
The first judgment is 2003 7 SCC 197 para 23. I would like to say that the facts of these 2 writ petitions are different and therefore distinguishable from the facts of the instant lease in issue. The Honorable Supreme Court had categorically stated that the decision of this Honorable Court is a decision on the case before the court, while the principle underlying the decision would be binding as a precedent which comes up for a decision subsequently. Your Lordship will kindly turn to para 23 of this judgment, page 206.
Yes, yes.
So far as Nagesh case relied upon by the claimant is concerned, it is only to be noted that the decision does not indicate the basis for fixing of a quantum of a lump sum was fixed by the court. The decision ordinarily is a decision on the case before the court, while the principle underlying the decision would be binding as a precedent in a case which comes up for decision subsequently. Therefore, while applying a decision to a later case, the court dealing with it should carefully try to ascertain the principle laid down by the previous decision. A decision often takes its color from the question involved in the case in which it is rendered. The scope and authority of the precedent should never be expanded unnecessarily beyond the needs of the given situation. The only thing binding as an authority upon the subsequent judge is the principle upon which the case was decided. Statements which are not part of the ratio residency are distinguished as obiter dicta, which are not authoritative. Your Lordship, 3069 and 6968 is clearly distinguishable. In my humble submission, he should not have bothered this Honorable Court with this.
Yes.
Then the next one is Bhavnagar University, para 59, internal page 130, 2003 to SCC 111.
Yes.
para 59, a decision is as well known and an authority for which it had decided, and not what it can logically be deduced therefrom. It is well settled that a little difference in facts or additional facts may make a lot of difference in the precedential value of the decision. So I have clearly distinguished those two cases does not apply in my case, Your Lordship. So in that view of the matter, I rest my case here. I am obliged, Your Lordship has given a very patient hearing.
And what about the other third one?
Which third one?
Haryana.
Third one, the same.
Haryana Financial.
Haryana Financial is para 19. That same thing.
Para 19.
19. Court should not place reliance on a decision without discussing as to how the factual situation fits in.
Okay.
So the factual situation is quite different, Your Lordship. So therefore, I rest my case here, Your Lordship. I'm deeply obliged. Your Lordship has given a patient hearing. And I'm sorry if I've said something I should not have said.
Absolutely not.
I'm deeply obliged, Your Lordship. With that, I'll pray before this honorable court to issue a mandamus to the director to issue the promotional order in favor of this writ petitioners who are found eligible and have been recommended by the DPC. I'm deeply obliged, Your Lordship.
Yes.
My lord, only one thing I like to point out, my lord. My basic case is that, my lord, the director is has issued the promotion orders, my lord, on the basis of the rules, my lord, because he cannot go beyond the rules, my lord. And assuming that first I said that there is no direct recommendation by the DPC to promote the petitioners, my lord. There is no direct recommendation. And assuming that some recommendations are there, but my lord, recommendation by the DPC is not binding upon the appointing authority, my lord.
But there has to be some reason.
Yes, my lord.
What are the reasons?
Reason is that he cannot issue the appointment orders, or he cannot select the candidates in violation of the rules, because
No, there is no violation of the rule, but you have been doing it from before, earlier.
if it has been done before in violation of the rules, that now the same cannot
No,
be.
see, violation of rule is only to the extent that expanding the horizon of zone of consideration, nothing else.
Yes, my lord.
Nothing
then
else.
How
So how now how you are going to fill up those posts? 89 posts. How you are going to fill up those 89 posts? Those remaining posts, how you are going to fill
My
up?
lord, in the next DPC, and more particularly, my lord, now the process is going on to amend this rule, my lord. New draft rule is under process, my lord. That rule is coming up, my lord. In fact, in the last week also, there was a meeting regarding that, because draft service rule has been prepared, I think, in the year 2018-19. That has not been finalized, but that is now in the process of finalization, my lord. And secondly,
So you do it, we'll set aside this order, you do it.
which order, my lord?
You will set aside this order, you come up with new guidelines, new rule, whatever.
Yes, my lord. Which order, my lord?
This, I mean, whatever that recommendation that you have given for others,
No,
but you have not given recommendations for these people.
because, my lord, if there are, suppose, 100 posts, as per the rule, my lord.
No, that is the problem happening here in this case, right?
Yes, my lord.
So you have only one seniority list.
Yes, my
and
lord.
you have two class of people, and you are making one seniority list.
Class is not recognized by the rules, my lord, 1991 rules. That
Which
is
class?
the problem.
Which class is not recognized?
The graduate class or diploma class, my lord, or academic side.
But you have given different qualifications for different people.
That qualification has been prescribed by the Indian Nursing Council, my lord.
Correct.
This rule is of 1991. That's why, my lord, the amendment process is going on, my
No,
lord.
that's why like you do something as soon as possible. Otherwise, they are facing
My lord,
problem.
that's why the draft.
No, that is why you'll have to prepare the draft and place it before the court as soon as possible. If you can place it before this court, then it's fine.
That has been placed before the division bench, my lord. Another matter is going on. We have placed it there, my lord.
What? Which? What? That
Draft service rule.
draft service rules you have replaced.
Yes, my lord. We have placed before the division bench.
Mm.
Another matter is going on there, my lord. Regarding this issue, my lord, graduate nurses and diploma nurses. And secondly, my lord, if we go by the recommendation, kindly have a look at page 189, my lord. Clause 9 says, my lord, for the post of existing vacant post of PSN Under DSS FW, Assam, 30% of posts shall be filled up by way of promotion from the cadre of staff nurses having BSc Nursing, post-basic BSc Nursing, who are under DSS, Assam and DME. And the remaining 70% of posts shall be filled up from the cadre of LHP, who have completed PSN diploma course under DSS FW, Assam. Accordingly, DSS Assam will share the details of so-and-so. So the writ petition number 6968.
I'll object to it. That was put to challenge in that subsequent writ petition, and that has been stated by this honorable court. Why is suppressing the facts?
Which one?
That recommendation. That's what I read now just before your honorable court, and I have annexed those orders. That recommendations of promoting 70% PHN for the 70% ANM for the post of PHN has been stated by this honorable
That's
court.
why I am coming to that writ petition. Why are you interfering? I am coming to that writ petition.
You cannot.
I am coming to the writ petition number 6968 2024. My lord, that 6968 2024, my lord, that writ petition has been, because in terms of this recommendation of DPC, there is another DPC by the DSS FW. So that DPC recommendation has been challenged in this 6968 of 2024. So there, my lord, if they say that, my lord.
No, their issue is different. Their issue is, about ANM and this thing, right?
That's the point I would like to say that, my lord, he is saying that ANM or LSB, they are not qualified. If your lordship, I will come to that point. Even from the perusal of clause 9.
So that is why the recommendation was challenged.
No, my lord. From clause 9, it is apparent that the the so-and-so shall be filled up from the cadre of LSB who have completed PSN diploma course. They are saying that they are not qualified or they are not eligible. And on earlier 2 occasions, my lord, ANM, LSB who have completed 1 year PSN diploma course.
Then they become eligible.
Yes, they become eligible. So it was the third DPC. On earlier 21 and 22, my lord, 2 DPCs were held where ANM having the PSN diploma course, they have been recommended, they have been promoted. Now they are challenging their eligibility. My lord, if earlier DPC has recommended them, now why they are challenging it?
No, they can challenge it anytime. There is nothing. Yeah.
I understand, but the logic is same, my lord. In this instant case also, my lord, rule doesn't permit it. They are now trying to rely on their case on an earlier DPC, my lord. That in the year 2017, 2 zones were created, my lord. If in that case they are challenging,
that cannot be there. Can I stop him from doing that? Can you stop him from doing that?
We cannot stop him. But why the stand of the petitioner are contradictory. And secondly, if they are contending that there are several vacancies of PSN, so in that case, my lord, 6968 2024, in spite of the ANM and LSP having PHN diploma course, in spite of they are having the requisite qualifications, my lord, why they have prayed for stay of their promotion to the post of PSN? Otherwise, many of them would have been promoted to the post of PSN, my lord.
He is arguing for whom?
Because 30% of PSN posts under the DSS FW were given to him.
I think your department should, do something on this. It's all haphazard.
Yes, my lord. That's why, my lord. I understand, my lord. That's why 1991 rules is sought to be amended, my lord. So that amendment process is going on, my lord. And the draft service rule in connection with another item we have, if your lordship.
What was that other item?
All Assam Nurses Association.
The issue is what?
Issue is, my lord, in that matter, my lord, the nurses having the grade pay, the staff nurses having the graduate degree, they have been given
different grade.
Different grade. And the staff nurses having diploma,
They are giving different.
different.
So they are challenging that.
Yes, my lord.
Because we do similar kind of work.
Yes, my lord.
Huh?
Yes,
That
my
is the
lord.
issue.
Yes, my lord. That
So
is
we
right.
do similar kind of work, but our entry may be different, but we are
Yes.
we are performing similar kind of job, so we
Yes.
should be given similar grade.
Yes, my lord.
That is what.
That is the issue, my lord.
Mm.
But the anomaly pay committee, my lord, recommended a higher
Rate for
grade pay
them
for the
because they are entry level, they are BSc,
Yes, my
and these
lord.
people are not.
Yes.
Mm.
Because
Once they
anomaly pay
complete post
committee
basic, they also get
recommended
the
that.
same.
That's why that issue has arose, my lord. They have been granted 8,700, and the diploma they have been granted 6,800.
So what is the stage now for the draft rule?
Doctor, in the last week only, there was another meeting with all the stakeholders, my lord.
In the draft rule, what is new coming up?
There, my lord, these issues will be settled, my lord. Clinical side, academic side, because basic issue is that, my lord, the here the petitioners who have got the graduate degree, my lord, probably they will be entitled for the academic side, PS and other things. So there, my lord, provision probably like the issue that we have faced here, my lord.
No, one more thing, you know why you have faced the issue?
Yes.
Because these people with graduate, I mean BSc degree,
Yes.
they are qualified for both the things.
Yes, my lord.
And that's why probably you have made one list only.
Yes, my lord.
Once in
Because 1991 rules, rule 22 provides for only one gradation only. But in the probably in the draft rules, my lord, there will be provision for academic side, clinical side. So all these issues will be sorted out then. my
So
lord.
there also then the problem will come about the seniority again.
Yes.
Because these people are qualified for both the both the jobs.
Whatever problems.
But you won't be able to stop this person
Yes.
from saying that like no, you are eligible, you are BSc, so you'll be considered for this post only.
Yes.
That cannot be done because both the posts they are eligible.
And that's why, my lord, on last occasion, my lord, there was a meeting with all stakeholders, the members of this, the petitioners, my lord. Their organization were also called to the meeting, my lord. So whatever problems are being faced, my lord, practically, my lord, all are have been discussed, my lord. So now thereafter it will be finalized, my lord.
So what is to be done now? Tell me.
It's up to your lordship, my lord. My humble submission is that, my lord, director, whatever he is doing, my lord, he is doing as per the rules, my lord. And there is a direction from the government also that whatever promotion exercise or whatever you take, my lord, yeah, everything should be as per the strictly as per the rules, my lord.
But DPC is aware of the rule. DPC is not aware of the rule. Then
my lord.
You have constituted a committee. Then why the committee is constituted then? See, DPC is not. It's not a like putting a stamp
Why, my
mark.
lord, I am
See,
saying.
DPC is a specialized body, right? Specialized body to consider the whole.
That's why I submit that DPC has not specifically recommended. DPC is saying that for the PSN this should be done, and for the assistant matron or ward sister one is ward insert this should be done, and the qualifications prescribed by the INC or all these things should be followed. But DPC has not recommended that they should prepare two zones, my lord. And otherwise, also, my lord, now whenever the appointing authority will take some steps, they will appoint, my lord. That has to be done as per the provisions of the rules. Because
No,
my
see,
lord, otherwise we don't
no,
have any problem.
Mr. Bora, another one more thing is that see, he has argued the one thing that earlier 2-3 times you have followed that. You have widened the horizon.
If one wrong has been
No,
same rank, the wrong cannot be
No,
continued to be.
now who has done it? Director has done it.
Maybe, my lord, if one
Director
has
has done
been committed, the same wrong cannot be allowed to continue every time, my lord.
No, whether it's wrong or
my lord, apparently it is in violation of the rule, my lord.
Only thing is that like that, yeah.
Because 11.2 clearly says that, my lord.
Only zone of concern is 1:4.
Yes, my lord.
Nothing else.
Nothing else.
Hmm.
And rule 22.
For
my lord.
1:4, there is nobody qualified.
Yes, my lord. And then rule,
And like, are you not going to promote anybody?
rule 22 then, my lord. Single gradation list.
Single gradation list is fine. There is
Yes,
no
my
problem.
lord. Then
But in case of 1:4 horizon, I mean that ratio.
Yes.
Ratio. If there is, I mean, if you are not finding people, whether you can expand the horizon or not, and that has been done previously.
That's what I am submitting that probably because of the existing rule, my lord, we are also facing some difficulties, my lord.
The difficulties we are facing, but you are not doing anything.
No,
Now you have started doing
we
it.
are doing, my lord.
Now you have started doing it when the issues have.
The draft service rules, my lord, for last several.
So many cases have come before
Yes,
this
my lord.
court.
Once that is, the problem is that, my lord, like in the last week, there was a meeting where, my lord, the concerned officials, the Graduate Nurses Association, All Assam Nurses Association, ANM and LSS Nurses Association, all were called, my lord. All the stakeholders were called for the meeting. Then, my lord, the suggestions from all sides have been invited, my lord. And probably every time one of the organization raises objection against the other, that's why it is taking some time, my lord. But very soon it will be finalized, my lord. Because even we are also facing the problem, my lord.
Okay, then we'll close it and like, you give me a written this thing.
I will
And
submit
you can put all these things also, huh?
Yes,
You
my
can
lord, I
put
will submit
all
my-
these things that the draft thing is going
Yes,
on.
yes,
And
my
what
lord.
is there in the draft thing, what you are planning to do, all these things also you can put in.
Yes, my
You
lord.
can
That
put
is-
it.
If your lordship wants that draft service rule that I have submitted before the division bench, then
Now that also you put it and like, and you point out what are the things you are planning to do,
yes, my lord.
correct?
My lord, regarding the draft service rules, I cannot say anything.
No, whatever is there in the draft service. I'm not.
Copy of the draft service rules.
I'm not saying that you say something.
Yes, my
But
lord.
draft service rules, if it is written clause 3, it will be done like this. That you can write, no?
Yes, my lord, I will submit my written argument on this case and I will submit a copy of the draft service rule. Then your lordship.
A copy to me also because that's a draft service. Your lordship, just quick
Hearing
reply.
is concluded.
Your lordship, just quick reply to this arguments. Your lordship, my learned friend is basing his arguments on permutation and combinations. Draft service rules will come someday. I have no object to that.
No. See, I mean, if draft rules is being prepared and by the draft rules your problem is solved, then what is there? What is there
Your
to like
lordship,
look into this matter?
In that, your lordship, let me put it in this way. This entire case happened when this draft rules was not in existence. So your
Now it
lordship-
is happening.
No, now it is happening. So therefore, your lordship will consider my case in terms of the facts which existed as on that.
I understand that.
So
But
that-
like, but only thing is that like if draft service rule is coming up, and if there is, I mean, I do not know when it will be coming up. I do not know. So I'll just, I mean, this court just want to look into, wants
Yes,
to
your
look
lordship
into
can-
what is there in the draft
Your
service
lordship
rule.
can look into it, peruse it, but your lordship will not pass any, I would say, my humble submission, your lordship will not take it other way. Your lordship will not pass the judgment based on the draft rules because that is not going to affect me at this stage. It will come into effect only from the day when it is implemented, your lordship, first of all. Secondly, I have demonstrated these last three judgments, which says that a judgment has to be read in the facts of the case. He is already time reading that 70% PH.
No, that will see, that will see.
He should have challenged it before the division bench. He has not gone for the stay vacating.
That will see.
As if he is doing the fielding for somebody else.
That will see. I'll just, I mean, all the things are there before this court. I mean, we'll see this. You give you this thing only to clarify your stand because since he has given it.
Yes, my lord.
I'm deeply obliged.
When can you give it?
My lord, within 2 days, my lord.
Just give it to him.
Yes, my lord.
You take 3 days also, no problem. 2-3
Yes,
days
ma'am.
you take.
Yes, 2-3 days, my lord. I will prepare it, my lord.
Okay.
And the one later, your lordship may see on the records, my lord, the meeting, my lord, in the last week only, for the draft service, there was a meeting.
Okay. You can-
Sorry,
I'm deeply obliged.
Where the stakeholders of all the.
Heard Mr. R. Singhal, the learned counsel, appearing for the petitioner. Also heard Mr. B.P. Bora, the learned standing counsel for health department. Hearing concluded, the judgment reserved. Yeah.
May the lordship kindly pass over the matter for the time.
Time being cannot be passed over now. Why?
Clearly,
We just in it.
BK Sen.
Hmm?
BK Sen. Advocate BK Sen.
Advocate BK Sen. We'll put it some other date then. You cannot put it this. Mr. Mahmood.
Reply also required in this.
Reply you haven't filed, Mr. Mahmood.
Against. Private respondent.
No affidavit has been filed by the section, received by the section.
It is. First time it has come today. Petitions affidavit.
BTC, are you not going to file any affidavit against reply affidavit? BTC? I think that is little be required. Have you filed it? No?
No, I have not filed. Against it, no affidavit.
Against BTC.
No.
BTC has filed an affidavit.
Yes, yes.
So you are not going to file reply to that?
Not yet.
Huh?
Not yet filed. Any
Are you going to file it? Because that may be required. That's what I'm saying.
Not that.
Huh?
And on the other hand, private respondent has not appeared today.
Okay, heard Mr. M.U. Mahmood, the learned counsel appearing for the petitioner. Also heard Mr. B.C. Musahari, the learned standing counsel for BTC, as well as MS.
For the respondent number 8 and 9.
Your name?
Missing.
So and so, on behalf of Mr. B.K. Sen, the learned counsel appearing for respondent number 8 and 9. Mr. J. Handick, the learned state counsel for 4 and 5. Mr. M.U. Mahmood, the learned counsel for the petitioner, prays for a short accommodation to file an affidavit in reply to the affidavit in opposition filed by the BTC. Full stop. Prayer is allowed. Let the matter be listed after 2 weeks.
Interim may kindly continue.
Interim order so passed earlier shall continue till the next date of listing.
Orders. May I please, your lordship? Your lordship, this matter is simple as regards your lordship, unfreezing of the bank account, your lordship. By marking a lien of the disputed amount of rupees 27,500. Your lordship, if it is agreeable to my learned counsel for the Union Bank of India, your lordship, the matter can be disposed of by directing the respondents, your lordship, to unfreeze the whole of the account and by keeping a lien of the disputed amount of rupees 27,500, your lordship.
Yes, your lordship, the matter may be disposed of in the light of other judgments that has been passed.
Which is the other judgment?
Your lordship, I don't have a copy of those judgments.
Then you should have carried it.
Yes,
What is the judgment?
Yes, your lordship.
No, what was the judgment passed?
So generally that the disputed amount will be kept in lien and remaining the accounts will be allowed for the
Operate.
office. Yes, your lordship.
Okay, then we'll dispose it of in that line.
Yes, your lordship.
My consent is, although I am consented, but I cannot give consent on records.
Huh?
I cannot give consent on records.
Then how will you give? Then how will I write?
No, that the other judgments.
Yes, your lordship.
Have you annexed any judgment?
Your lordship, I have cited a judgment at page number 17.
Citing, how citing will do?
Yes, your lordship.
The matter may be fixed day after tomorrow so that I can bring the.
Yes, your lordship, even I can also produce certain judgments, your lordship.
Okay, on the joint prayer of the parties, let the matter be listed day after tomorrow. That is on 27th.
Yes, sir.
You bring that on record. We'll see what was the order passed. Otherwise, I think there shouldn't be any problem. A small amount, you keep that on, keep that as security.
Yes, sir.
No, it is kept in lien and other,
What will be the difference of lien and security in here?
security means your lordship FDs and all other
Hmm?
things. FD and other things. will
No,
be
that's a different thing. I'm saying that like you keep this much amount as security and like allow other amounts to be transacted. And like the order, it seems that like they have passed as lien. So what will be the difference? That's what I'm asking.
Your lordship, in the lien, the amount will not be vanished from the statement of account.
And the security?
And in security, it has to be vanished because either I have to pass in debit entry or credit entry in said regards. And it is kept to the other head of the accounts.
Okay.
That is the only.
There may be some difference.
Yes, sir.
Okay, bring that.
Yes, I'll do bring. I'll do.
Much obliged, Your Lordship.
47.
I think this can be RS Chaudhary is there. She was sitting here some time back. I think we can dispose of this. I mean, only for this thing. Okay, we'll put it up. Release this matter after none appeared for the petitioner when the matter was called for. Let the matter be listed on 27th. This is only regarding withdrawing from the case.
81.
May I please Lordship, I am on behalf of Mr. M. Surya. Lordship, kindly adjourn this matter to. Adjourn this matter to. Kindly give 1 week.
They have not been appearing in the
Well, then they did not take steps.
You don't take steps, you don't appear. What is this?
Lordship, earlier did we are here.
Earlier date or no, it says that there is nobody appeared on 19/5. 19/5, nobody appeared.
Sorry.
No steps has been taken. Who is your senior?
Mintu Shoyke, M.
Where is he?
He's not, his personal difficulties. We are not going to come.
Okay, we'll pass it off. Okay, on the prayer of the learned counsel appearing for the petitioner, let the matter be listed after a week. Finished.